to my account so you can see. Hello everybody. Welcome. I'm just getting things set up for tonight's live. So just need a couple more minutes to get everything put into place. Hopefully everyone is having a good night tonight. A lot of things going on in the world. Yes, we're going to talk about the rules tonight. This has been a really hot topic recently. And it looks like there might be some movement on this issue within this next week or so. So I wanted to kind of give everyone an overview of the rules before that came into play. So right now I'm just trying to kind of adjust everything. Please let me know if it's in frame okay for everybody. This is a little bit different than when I'm lecturing in a classroom when it comes to how things look visually. But welcome. Thank you for joining tonight. Thank you very much. Good to see everybody. I will be going through the judicial ethics required for our federal judges tonight, as well as the judicial ethics that the U.S. Supreme Court, according to Chief Justice John Roberts, what he has set out. Did I see Gorsuch's comments? No. Did he make something recently? Did he comment recently? I've seen a lot of comments over the last little bit, but so you'll have to let me know if there has been anything that has recently that I may have missed. It seems there's been a lot of movement. It's getting a bit more difficult to kind of clear out all of the political issues going on here and keep it just to the law. So a lot of the comments, a lot of the comments that I'm seeing in the media are really so politically biased, one side or the other. I'm not blaming one side or another, but it's hard to kind of, weed through all of the politics to get to what's really going on. So there we go. How is that? Is that a bit better? I will be starting here shortly. I'm just on early to say hello to everyone, but I'll be starting with this letter, Chief Justice Roberts' letter to the Senate Judiciary Committee soon. So I will start by going through that. We had a Senate hearing just this past April regarding ethical concerns. There was some legislation that's been proposed. The court is operating at highest judicial level. Yes, and it seems that, the justices, we're in a bit of a tight spot here because the justices are claiming this high level of ethics, but yet they seem to be really pushing against any kind of oversight. So we will see what happens, but I want to take you through kind of the language of the different kinds of laws that are at play and rules and regulations when it comes to ethics in our judiciary branch. So we'll kind of go through those things tonight. But this letter outlining the role of ethics with the U.S. Supreme Court was signed by all the justices. And there's some, I guess, comfort perhaps in that, but also, we don't know the rationale behind why all the justices signed this letter. So we don't have a lot of support for it. All we have are signatures. So I think that's interesting to note. Usually we have all of our justices really are relatively chatty. That's kind of their job. And there's not really a lot here other than just the signature of our justices in order of seniority, of course. So I'll kind of talk about that a little bit, but Chief Justice Roberts really set out very concisely what he thought the ethical code follow what he's talking about in here, and if it's enough, we will see. Who could oversee SCOTUS without an amendment? Well, and that's a lot of what we'll get into tonight, because we have had ethical rules that even Chief Justice Roberts acknowledges. We have rules that they have to follow. And so the same way that they have to follow the rules, and I'll go through all of these, the way that these rules are enforced would be the same way that the ethics rules would need to be enforced. But at the end of the day, what the proposal is, what the most reasonable proposal has been for the Supreme Court to make their own rules and to set that up themselves, and how they want to go about doing that, just like any of our other branches of government have all set up their own rules. So yes, and accepting gifts has its own set of rules, and there's an entire section just on what gifts are allowed and how they're allowed. So I will be going through that also here in just a little bit, but that's a huge issue. It's a huge accountability issue. So I will definitely be getting into that. Okay, so welcome. It's good to see everybody. I'll go ahead and get started. What a great question that you have to start off with. So I've got a lot of different things to show everybody tonight, and I will just tell you where you can find all this information yourself, go through it with you, and then whatever you decide, then I think that's a fair and honorable decision. But first, let's talk about the other branches of our government first. We'll just get started with that. Since you asked, we have for our legislative branch a code of official conduct, and these are the rules of the House of Representatives for this Congress. So this has been set out via the rules, and not only the House of Representatives, but also the Senate. We have a Senate ethics manual. These are the rules that govern the ethics of the Senate. So we have two branches here that have their rules, the Senate and the legislative branch. So these are set out. Now you'll note what's very interesting. Yeah, it seems, it's interesting. When we look to the Constitution and the language in Article 1 that establishes Congress, the fact that the House of Representatives and the Senate need to set up rules for their own governance is set out here. So it goes into how Congress is supposed to go forward in setting out their own rules. So that is clearly set out in Article 1. What's interesting, though, is if we flip to Article 3 that establishes the U.S. Supreme Court, there are no rules regarding how the Supreme Court is supposed to operate. So that's something to just know, just right off the top. We've got ethical rules for the House. We have ethical rules for the Senate. That takes us next to the executive branch. Well, what about the president, vice president, and all of the areas of the executive branch? Well, they also have ethical standards and rules of ethical conduct that they have to follow, or they can get called out on it. So it's extensive. It's very clear. So for the executive branch, we've got general provisions, we've got gifts from outside sources, how that's supposed to be handled, gifts between employees when it comes to anyone in the executive branch, conflicting financial interests, what happens with that. We have also, again, these are the ethical rules just for the executive branch. Other employment, if you're also in the executive branch at the same time, misuse of position for the executive branch, outside activities. So all of these things are set out in a code of ethics, specifically to the executive branch. So they have their rules. So we've got two of our branches with ethics. Now, the overreaching or over ensuing piece of law that governs all government acts here is the Ethics in Government Act of 1968. I will go in through this in more detail here in just a bit. This is the overall ethics rules for anyone working in government. Now, the U.S. Supreme Court justices work for the government. They get paid by Congress. They get chosen, picked by the president, approved by the Senate to take their positions. So although the content or the substantive law in their cases, nobody has anything to do with that, of course, but when it comes to the administrative purposes of that, we have a couple of other branches of government that are set into place. So I will get into this particular act in more detail here in just a little bit. But what I wanted to point out is we do have in Article 3, we set out all of our federal courts, and also in Article 1. So whatever federal courts are needed, set out by Congress. This is just a showing of all of the different circuits, the federal circuits that we have in the United States. So if you are a federal judge anywhere in the United States except the U.S. Supreme Court, there are a set of ethics that you have to abide by. And we have an entire group of people who are in charge of implementing those ethics and making sure that everyone follows them. We have also an Ethics Reform Act of 1989, which kind of covers everyone as well. I'll be talking about that just a little bit, but I don't want to get too far into the exact letter of the law. I want to show you more where the resources are to find what you're looking for. So when we're talking about the ethical rules that apply to our federal courts, we're talking specifically to a set of rules that were set out by the Judicial Conference of the United States. So these judges, all of them, are the ones that are in charge of it. And if you go online, you can pull up the Code of Conduct regarding the federal judiciary branch. This is an example of a piece of it here. And it's specific to published advisory opinions. There's a lot of detail involved in the ethical policies regarding the federal judges. Again, this is a great example because this advisory opinion piece is huge. It's very specific about federal judges. and their ethics. And this is just for the advisory opinions. But if we look here to the overall code of conduct for United States judges, we set out the code of conduct for public defender employees, judicial conference regulations, financial disclosures required by federal judges, gives to the judicial branch mandatory conflict screening policy, which is huge if there's a conflict of interest. Also, what kind of social media situation is allowable. So all of these things are very specifically set out for the ethics regarding federal judges. Now, typically when we have who picks the people that are on the committee, well, that's a great question. Whenever we have an advisory committee put together, particularly in an ethical capacity, the people within the legal community go about and look to those who are kind of the most trusted, well-known in the business, hopefully the most honorable, and are willing to do the job. And then they get, stopping by from Pennsylvania, well, hello. And they get nominated, and then they get chosen. So they go through a process of being chosen by their peers, by people in the legal community, other attorneys and judges. They pick basically the best of the best to join the committee, and they are the ones that make up the committee that goes on eventually and writes these policies. Again, you can see here, this is the exact people that we're talking about. So we have a Chief Justice, almost all of them are Chief Justices. For the first, second, third, all of our circuits here, District of Columbia Circuit as well. So these are the justices that are just at the judges that are at the top of their field. So the top judges are chosen, and then each one or two of them are sent in from the different circuits, and they make up this judicial conference. So, and Chief Justice John Roberts is the one who presides over the judicial conference of these judges that write and amend the rules for ethics for the federal judges. So follow me here. We've got Chief Justice Roberts presiding over the judges that write the rules for all of the judges in our federal courts. So all of these judges are governed by these rules, and these rules are set out by a committee that Roberts oversees and presides. So, well, he's the Chief Justice, so that's his role. He has a lot of specialized roles as a Chief Justice, and that's one of them. So when we go to the federal judges' requirements for the Code of Conduct, we look specifically to this part. And again, like I showed you before, there are just huge, huge batches of rules on how to go about doing it. So we'll just use publishing advisory opinions as an example. And it seems line by line. So if you've got a membership in a political club, disqualification based on stock holdings by household family members, financial settlements, disqualification on resignation from a law firm, disqualification based on holding insurance policies from a company that's a party to a case. So these are very, very specific rules. Limited solicitation of funds for the Boy Scouts of America, service as a co-trustee, service as an officer or trustee of a professional organization. So step by step, we have all of these very specific rules governing just the advisory opinion portion of what federal judges can do. Disqualification when a judge is a utility rate payer or a taxpayer. What happens when we've got United States Attorney as a law clerk's future employer? So if you're employing someone and they are off to be a United States Attorney law clerk. Membership and participation in the American Bar Association, that's covered. All of these are clear rules they can go to and look up any question that they have. So if I've got a question on gifts to newly appointed judges, and what ethical rules I need to follow regarding that, I would go to number 98. So let's just take that as an example and hop on over to Rule 98. Let me see if I can get it pulled up here. Well, actually, let's just look at number 19 since it's right on top here. A membership in a political club. And again, if you can't see this, just let me know and I can move it better into frame. But this is a question if we've got a federal judge who is involved in a political club. What happens? We go into what the canon says, so what's the rule? And then we go into what a judge should not do. So here's an example. A judge cannot act as a leader or hold any office in a political organization, make speeches for a political organization or candidate, or publicly endorse or oppose a candidate for public office, or solicit funds for, pay an assessment to, or make a contribution to a political organization or candidate, or attend or purchase a ticket for a dinner or other event sponsored by a political organization or candidate. So this is the requirement for federal judges, and you can see how specific it is. And these rules, again, are line by line and multiple sections over and over and over again, trying to go into what a judge can and cannot do ethically at the federal level. These rules, again, only apply to the federal judges. These are not applicable to the U.S. Supreme Court. And the question has become, should these same rules be applied to the United States Supreme Court? Because they are applied to the federal judges, so why not include the U.S. Supreme Court in that group? So a lot of questions about that. Another really good point that they have for the federal judges is a mandatory conflict screening policy. And that is very, very detailed when it comes to our federal judges and what those conflicts of interest are going to look like and what's allowed and what is not allowed. They're very particular about those pieces, and the rules are pages and pages and pages worth when it comes to that kind of conduct. So this is really important. And I think one of the biggest questions happens to be those rules and more should apply to the Supreme Court. Yes, and that really is one of our biggest questions is, if the federal judges have these ethic rules, why can't the U.S. Supreme Court? So, and I'll get into that a little bit, and we'll kind of go through exactly what Justice Roberts claims is the reason for that. So just again to kind of go through an overview of the Code of Conduct for United States judges, this is really our background before we jump off into what the U.S. Supreme Court claims should be their ethics. But here are the primary canons. Canon 1, a judge should uphold the integrity and independence of the judiciary. Canon 2, a judge should avoid improperly and the appearance of impropriety in all activities. Canon 3, a judge should perform the duties of the office fairly, impartially, and diligently. Canon 4, a judge may engage in extrajudicial activities that are consistent with the obligations of judicial office. Canon 5, a judge should refrain from political activity. So these are the key canons for the judges in the federal system. All of the federal judges, except for the U.S. Supreme Court. The U.S. Supreme Court has said these rules do not apply to us. Now, let me take you through how they've gone about that rationale. Again, we've got to go to the U.S. Constitution that sets out our judicial branch. And if we go to Article 3, the judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during a good behavior, and shall at stated times receive for their services a compensation which shall not be diminished during their continuance in office. So that's the life appointment piece of our justices. Second, the judicial power shall extend to all cases in law and equity arising under the Constitution, the laws of the United States, and treaties made, or which shall be made under their authority, to all cases affecting ambassadors, other public ministers, and councils, to all cases of admiralty, maritime jurisdiction, controversies, which the United States shall be a party, to controversies between two or more states, between a state and a citizen of another state, between citizens of different states, between citizens of the state claiming lands under grants, different states, and so on. This is more of a piece of the jurisdictional piece. So this was outlined and kind of updated a bit as time went on. The trial of all crimes, except for cases of impeachment, shall be by jury, and such trial shall be held in the state where the said crime shall have been committed. That's another jurisdictional piece. And then we have a piece on treason. Treason against the United States shall consist only in levying war against them or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of two witnesses to the same overt act or on confession in open court. The Congress shall have the power to declare the punishment of treason, but no attainder of treason shall work corruption of blood or forfeiture except during the life of the person attainted. So that's it. That's all that Article 3 says about the U.S. Supreme Court. So we've kind of got some questions. When it came to our federal courts, it seems like there's no issue in establishing ethics for our federal courts. That's not the problem. The problem is establishing those ethics for the U.S. Supreme Court and exactly who would oversee the ethics and the rules regarding the U.S. Supreme Court. I think a great explanation comes through this letter Chief Justice Roberts sent to the Senate Committee on the Judiciary. And I want to walk through the language he has put in here because he cites a lot of different sources and explains what he believes is the appropriate guiding force behind ethics for the U.S. Supreme Court. So let's get through this letter, and I will break apart each of the different citations that he has here. So keep in mind, this is a response to the Senate Judiciary Committee asking him to come in and testify to Congress. Now, he said he did not want to testify, and this was his letter in response. He refused to come in, and this is why. This was dated April 25th of 2023. So here we go. Thank you for your letter of April 20th of 2023, inviting me to appear at a Senate Judiciary Committee hearing on May 2nd. I must respectfully decline your invitation. Now we'll get into Chief Justice Roberts' rationale behind all of it. Yes, they do. And, as I go through this, I will kind of walk you through some of the history that we have in the separation of the three branches. And, many times justices have testified in front of the Senate and in front of Congress. And Congress has issued multiple laws that handle the administration of the U.S. Supreme Court. Ethics could be seen as an administrative duty, and therefore the power to set out the idea that they need to have ethics could be seen as a congressional power because of the way that the three branches were divided. Now, who actually would write those rules? I believe the consensus repeatedly has been asking the U.S. Supreme Court to write those rules themselves. That tends to be the overall question. And both sides are agreeing to that, although the U.S. Supreme Court is not. So, testimony before the Senate Judiciary Committee by the Chief Justice of the United States is exceedingly rare, as one might expect in light of separation of power concerns and the importance of preserving judicial independence. The Supreme Court Library compilation of justices testifying before Congress in matters other than appropriations or nominations has been identified only two prior instances. Chief Justice Taft in 1921, which you'll keep in mind, we also had Chief Justice Taft as a president. He was the only president that's also served on the U.S. Supreme Court. And in 1922, Chief Justice Hughes in 1935. Both hearings involved routine matters of judicial administration relating to additional judgeships in the lower courts and jurisdiction over appeals from lower court injunctions. So Chief Justice Roberts acknowledged that before we have had a couple of Chief Justices who have testified regarding the administrative issues involved with the U.S. Supreme Court. My predecessor, Chief Justice Rehnquist, appeared before House committees twice, also on mundane topics. In his first appearance in 1989 before the House Committee on Post Office and Civil Service, he offered views on improvement to the federal civil service system. In 2004, he discussed the John Marshall Commemorative Coin Act at a hearing of the House Financial Services Committee. Neither Chief Justice Berger, nor Chief Justice Warren, nor Chief Justice Vinson ever appeared before a congressional committee, though Chief Justice Warren did submit a prepared statement on a federal employee salary increases to the Senate Post Office and Civil Service Committee in 1964. Again, this is reiterating this point that the administrative part of the U.S. Supreme Court is something that is dealt with at a congressional level. LB, you raise a good question, a Republican-appointed court. Now, what I would say to that is, since the beginning of our U.S. Supreme Court, we've had different views on how conservative or liberal our court has been, and it's kind of gone back and forth, although really 7 out of 10 times it has leaned more conservatively. But that has just been the process of the U.S. Supreme Court. So we're continuing on with what has happened. But what's different this time is we are asking the Congress, the people, we are asking for some specific ethical rules. Now, this is the first time that's been occurring. We've set ethical rules. Congress has set out multiple acts regarding ethics, but now we're specifically saying to the U.S. Supreme Court, hey, can you write up some ethical rules? So that's really what the discussion is about. Yes, everyone, ethics is key. I mean, ethics is absolutely key for everyone, particularly attorneys. We all have ethics that we have to follow. Congressional testimony from the head of the executive branch is likewise infrequent. According to the United States Senate website, no president has ever testified before the Senate Judiciary Committee, and only 3 presidents have testified before any congressional committee. So I think he's trying to talk again about the separation of powers, with him as the role of the Chief Justice being equivalent to the President of the United States. In regards to the court's approach to ethics matters, I attach a statement of ethics, principles, and practices to which all of the current members of the Supreme Court subscribe. So we will go into what those are. Right. So, I think it would be a misrepresentation to say that how things went down for Justice Gorsuch's nomination and acceptance were controversial. I think that really has kind of lit the fire for this whole situation because there was such a huge conflict in that situation. So that absolutely plays a role. I did not see the Reverend who testified. That's interesting. I'll have to look into that. So let's flip over. We've got here Senator Durbin, who's the chair of the Judicial Committee. And then we have the ranking member, Senator Graham. So this was sent to both of them. So let's get into the details of what Chief Justice Roberts himself, what he claims are the U.S. Supreme Court's ethical rules. Let me just make sure. Am I in frame? I want to double check and make sure everyone can see my document here. So just let me know if I'm out of frame or if you need me to zoom out, because this is important. I want to make sure everyone can see it okay. Yes, I think Questions are great. Oh, good. Thank you so much for letting me know. I think that's great. My whole hope and goal is to give you information so you can absolutely ask your own questions, not just even my questions, but your own questions. So let's get into Chief Justice's rationale here. The undersigned justices today reaffirm and restate foundational ethics principles and practices to which they subscribe in carrying out their responsibilities as members of the Supreme Court of the United States. This statement aims to provide new clarity to the bar and to the public on how the justices address certain recurring issues, and also seeks to dispel some common misconceptions. Okay. My hands are in the way. I'm kind of using them as I would my pointer, so since I don't have a cursor on the screen. The justices, like other federal judges, consult a wide variety of authorities to address specific ethical issues. They may turn to judicial opinions, treatises, scholarly articles, disciplinary decisions, and the historical practice of the court and the federal judiciary. They may also seek advice from the court's legal office and from their colleagues. Now, as a quick side note, I do have a couple of letters that I will be sharing here as we go on from the office that he's talking about here. We have two letters. One was in 2021 and one was in 2022. This is legal counsel going into the hospitality, the personal hospitality questions that have been asked. And I will go through that here in a bit. So that's what he's referring to, the court's legal office. In 1922, Congress instituted the Judicial Conference of the United States, which is what I had just shown you before, that conference of judges from all of the circuits, as an instrument to manage the lower federal courts. The Judicial Conference, which binds lower courts, does not supervise the Supreme Court. Nevertheless, for a century, the conference has contributed to the development of a body of ethical rules and practices, including, through the lower court, code of conduct, which are of significant importance to the justices. So they're of significant importance. So they have no jurisdiction, he's saying. This conference has no authority, but they're important to the justices. Next, we've got, as the commentary to Canon 1 of the lower court states, and I could pull those out again. Let me just make sure I get my canons set out. This, again, is going through those canons that we just talked about. Its provisions are designed to provide guidance to the judges and nominees for judicial office. Many of its aspirational provisions are necessarily cast in general terms, and judges may reasonably defer in their interpretation. The canons themselves are broadly worded principles that inform ethical conduct and practices, but they are not themselves rules. Now, this line, as an attorney myself, who is actually make sure that I follow my ethical rules every day, the fact that he is setting out that these canons are not rules, I think is a bit of a rudimentary explanation where he's kind of trying to say, look, I guess you guys don't understand what a canon is. And so let me just tell you that canons are just suggestions. They're not actual rules. Which, on the one hand, technically is true, but on the other hand, it's those canons that inspire the rules. So that would be a pretty generous reading of the term canons. Now I'm looking here to see if I can pull those canons up. I keep dropping them and then picking them up again. This is when I wish my paralegal was with me at the moment, but alas, paralegals need rest too. So here we go. Canons are these overall ideas. So we have this general idea for Canon 1, for example. A judge should uphold the integrity and independence of the judiciary. So that would be a canon. Under that canon, they will go through and give very, very specific rules. So this is basically, a canon is that Roman numeral 1 of an outline. So is it specific law? No, but it's what all of the laws or all of the rules are based on. So Canon 1 says this is what we need to do, and the rest of the rules explain how to go about doing it. So it's this idea of substantive versus procedural law that is really the overall issue time and time again when it comes to ethics. So that just gives you kind of an introduction. The only reason why this language is used is because that's how it's always been used. It's just legalese in the legal field, and it kind of keeps things at a level that makes it inaccessible to most people. So in my humble opinion, and not to be any kind of negative towards the Chief Supreme Court Justice, that would go against my ethics, but he's trying to set out a very rudimentary distinction between this idea of what should be done versus the actual rules themselves. So he's nuancing that and specifying again that this is for the lower courts. The canons themselves are broadly worded principles that inform ethical conduct and practices. They're not themselves rules. They are far too general to be used in that manner. Still, the canons of the Judicial Conference's Code of Conduct as a whole provide guidance to the federal judiciary. And again, he's referring to the federal judiciary as those courts, not the U.S. Supreme Court. Oh, do I sound stressed? Oh, I was stressed for a minute, but I'm doing okay. I'm doing okay. But thank you for asking, Tower Frost. Good to see you. Appreciate you joining tonight. Okay, so I guess this issue is very intense for me. I'm very intense about judicial ethics. This is one of the things that is very hard for me to understand the U.S. Supreme Court on. Like, I can understand why their decisions are one way or the other. I may not agree with it, but I can understand their rationale. But the Chief Justice's rationale in this letter is complicated for me, so I do struggle a little bit. Yes, it is. It is a stressful time, but let me continue on, and maybe you'll feel less stress as we go through the language. In 1991, members of the court voluntarily adopted a resolution to follow the substance of the Judicial Conference regulations. Note this term voluntarily adopted, meaning they chose to adopt it. Since then, justices have followed the financial disclosure requirements and limitations on gifts, outside earned income, outside employment, and honoraria. They file the same annual financial disclosure reports as other federal judges, again, because they voluntarily adopted this resolution. That's very important to note here. He's saying, we tried. We said, sure, we'll follow your rules. And so we're, letting you have the privilege of us saying, fine, we'll follow your rules. Is kind of how it feels, I guess. Those reports disclose, among other things, the justice's non-governmental income, investments, gifts, and reimbursements from third parties. Now, also, I think this would be very, very important to note when I'm talking about the U.S. Supreme Court. I'm talking about everybody. I don't care what side you're on. I think every single justice. And if you look back at the justices with their gifts and with reimbursements, it's a problem for all of the justices, not just a couple or one particular ideology. It's everybody. That's why there's such a push right now for these kind of standardized ethical rules. For purposes of sound administration, the justices, like lower court judges, file those reports through the Judicial Conference's Committee on Financial Disclosure. And again, this is that committee that the Chief Justice oversees. That committee reviews the information contained in these reports and either finds them to be in compliance with applicable laws and regulations or sends a letter of inquiry if additional information is needed to make that determination. More generally, the committee provides guidance on these sometimes complex reporting requirements. Just last month, for example, it provided clarification on the scope of personal hospitality exemption to the disclosure rules, and I will get into that here in just a little bit. Allegations of errors or omissions in the filing of financial disclosure reports are referred by the Secretary of the Judicial Conference to the Committee on Financial Disclosure. the committee may send the filer a letter of inquiry, providing an opportunity for the filer to respond as appropriate. So that's how that. Yes, and I wouldn't necessarily say, Sotomayor, Kagan, and Jackson. Well, Jackson, honestly, Justice Jackson just hasn't been there that long. But arguably, there have been a few instances with Justice Sotomayor and Justice Kagan where there could be a question about whether or not it was appropriate. Was it a huge yacht? No, but it could have been a question, and one that could be resolved easily by having a set of rules for everyone. So I think we're definitely dealing with different levels, but I don't think we could say that there would be no questions to be asked of them. Again, overall, for all the justices, with the exception, actually, there was a bit of controversy about Justice Jackson after she first joined the Supreme Court, because right immediately after, just a few days afterwards, there was a reimbursement request, which was fine under the current rules and probably still would be fine. But it's, a valid question. And there aren't any specific rules set out saying one way or the other on what she should have done in that situation. I think, it's a valid question for all of the justices. In regards to the financial disclosure requirements relating to teaching and outside earned incomes, the justices may not accept compensation for an appearance or speech, but may be paid for teaching a course of study at an accredited educational institution or participating in an educational program of any duration that is sponsored by such an institution as is part of the educational offering. And this comes out of another regulation. Now, you may note that Chief Justice Roberts taught a class in London on the Chief Justice, the U.S. Supreme Court, and he was compensated for that, as someone teaching a course would be. As the commentary to Canon 4 of the Lower Court Code observes, as a judicial officer and a person specially learned in the law, a judge is in a unique position to contribute to the law, the legal system, and the administration of justice, including through teaching. Associate justices must receive prior approval from the Chief Justice, so that would be him, to receive compensation for teaching. The Chief Justice must receive prior approval from the court. And then here's another resolution that they adopted in 1991 regarding that. This is just a reference again to those administrative procedures that the court is saying they need to follow. Yes, well, thank you, Scott. I am starting to publish them slowly on a YouTube channel that I do have just for that purpose, actually. So I will be posting as soon as possible after this live tonight. The lifetime appointment of SCOTUS justices really needs to go. Well, and that's a hotly debated topic. That is fundamentally written into Article 3 of the Constitution. It is specified that they are to be lifetime appointed. And that is such a fundamental piece of the Constitution, of Article 3, that it would require a constitutional amendment in order to change that. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior. So that's it. They have to be on there now for life. Another huge question, though, with the lifetime appointments has become, what if a judge or a justice, and this has happened over and over and over again in the history of the court, what if a justice is honestly too ill or is starting to display signs of an illness that maybe they should step down, but they're not stepping down? And what can be done about that? Because they are appointed for life. And until they decide to resign, unless another Supreme Court justice really pushes them, which has happened a couple times, but it's rare, the justices stay as long as possible, and many of them pass away in that capacity. Sure. Yeah, my YouTube channel is just my same username under YouTube. So, here we go. Let me make sure that I tried to keep myself on track here, but when I've argued in front of the federal court before, they always toss questions. And so you've got to jump right back into your argument after you answer questions. I have not argued in front of a federal court in a while. So let me take a minute here to jump back in. Here we go. Justices may not have outside earned income, including income from teaching, in the excess of an annual cap established by statute and regulation. So I think it's important to note here that a cap on how much they can make has been established by statute and regulation. So a lot of this letter goes into the fact that Congress should not have the power to ask the court to set out ethical rules. But the counter argument to that is, well, they have set out things like income. There is a statute and a regulation on income. And if they can set out income parameters, why can't they set out a requirement to have a code of ethics? So those are both sides of that argument there. In the calendar year 2023, that cap works out to less than 12% of a justice's pay. Compensation for writing a book is not subject to the cap. And that's pretty big because that's where a lot of the big money is typically when they are writing books. Yes, and sold separately. Term limits when they're basing decisions on personal beliefs. And I get it. I absolutely get it. I would, with that, just say if you look back all the way back to Chief Justice John Jay, our very first U.S. Supreme Court Chief Justice, and his role in writing the Federalist Papers and how that contributed to some of his decisions, I would say his personal beliefs were involved. You could say that about almost every single justice on the bench. After all, they are humans, but there have been, some questions. I mean, it's a good question. They're supposed to be neutral. And what does that role of neutral mean? And is it still mean the same thing now as it did when the original Supreme Court was put into place? That's a valid question, but that question dates back 230 years. Like lower court judges, justices also engage in extrajudicial activities other than teaching, including speaking, writing, and lecturing on both law-related and non-legal subjects. In fact, the lower court canons encourage public engagement by judicial officers to avoid isolation from the society in which they live and to contribute to the public's understanding of the law. Now, I would take this moment to say there are a lot of ideas that the justices live in an ivory tower, if you've maybe heard that phrase before, where they are really out of touch with the people. And so what the Chief Justice is saying here is that we need to go into the community so that we can kind of make sure that we are still part of this community that we're trying to be presiding over. But in deciding whether to speak before any group, a justice should consider whether doing so would create an appearance of impropriety in the minds of reasonable members of the public. Again, this term reasonable members, what does that mean? There is an appearance of impropriety when an unbiased and reasonable person who is aware of all relevant facts would doubt that the justice could fairly discharge his or her duties. So that's the standard he's using. Except in unusual circumstances, no such appearance will be created when a justice speaks before a group associated with an educational institution, a bar group, or a nonprofit group that does not regularly engage in advocacy or lobbying about issues that may be impacted in cases that come before the court. And that's a pretty bold statement, I think, but how many justices have there been? I think last I checked there was, and maybe somebody can Google it for me, but I think maybe around 125 overall. I believe. Implicated, right? Thank you. In regard to recusal, this is another huge issue, is this idea of recusal. And this is one of the arguments for whether or not to expand the U.S. Supreme Court justices, whether we should add more in case a justice needs to recuse themselves from a case, then we have some backup judges, so to speak. That's the argument. I'm definitely not for that, or against that necessarily. All right, I'll be honest. I'm against that. I'm not a big fan of expanding the court. It would be a lot more work. I think we would have a lot more turmoil, in my opinion. But that's one of the reasons, is because of this recusal idea. The justices follow the same general principles and statutory standards as other federal judges, but the application of those principles can differ due to the unique institutional setting of the court. In some instances, the justices' recusal standards are more restrictive than those in lower court code or the statute. For example, concluding that recusal is appropriate where family members served as lead counsel below. And I guess I don't know why that would be more restrictive, but that's what he's saying there. A recusal consideration uniquely present for justices is the impairment of a full court in the event that one or more members withdraws from the case. Lower courts can freely substitute one district or circuit judge for another. The Supreme Court consists of 9 members who always sit together. Thus, justices have a duty to sit that precludes withdrawal from a case as a matter of convenience or simply to avoid controversy, which is an interesting point. And he's citing this case, which is the U.S. v. Will case, which I've taken a look at, and that just reiterates this point here. But there's a citation if you're interested in that. We also have 28 U.S. Code, Section 455, and then the ABA Model Code of Judicial Conduct. ABA is the American Bar Association, and they have a model code for judicial conduct as well as for attorney conduct. So that's where he's pulling this idea that the preclusion of withdrawing from a case because there's just not enough justices to cover it, which I think is an interesting argument. Individual justices, rather than the court, decide recusal issues. If the full court or any subset of the court were to review the recusal decisions of individual justices, it would create an undesirable situation in which the court could affect the outcome of a case by selecting who among its members may participate. That's an interesting idea. I can see what he's saying with that. No need to expand, just fire one at a time. Well, oh dear. What about alternates? Yeah, that's an interesting question, isn't it? What if we did have some, for our juries, we have alternates. And so we've got people that sit and listen to all the evidence, hear all the arguments. But when they go into deliberation, if we still have our full original panel, then the alternates are excused. And so would something like that be practicable in the U.S. Supreme Court? I don't know. It's an interesting idea. I think it's a very interesting idea. There have been 116 justices. Okay, good to know. Yeah, I thought there really haven't been that many, which reminds us of how young our judicial branch really is. Recusals are noted in the court's decisions, both at the certiorari and merit stages. In recent years, there have been approximately 200 recusals per year at the certiorari stage and a few at the merit stage as well. In many instances, the grounds for recusal will be obvious. For example, when recusal is due to a justice's prior employment as a circuit judge or in the office of the Solicitor General. And of course, this is probably a reference to Justice Kagan. In some cases, public disclosure of the basis for recusal will be ill-advised. And that may be, I think, a public disclosure of why they're coming off of the case could really open up a debate for whether or not it's appropriate. So I guess I can see where he's coming from on that. Yes, the procedure to impeach a justice is the same procedure you would use to impeach the president. So that is governed under Article 2 of the Constitution. So all of those initial steps you would go through the same exact process. Putting things together, impeachment in the House, and then the Senate would try the situation and then give the ultimate verdict in that situation. In some cases, public disclosure, would be ill-advised. Okay, examples include circumstances that may encourage strategic behavior by lawyers who may seek to prompt recusals in future cases. I think that implies a bit of a distrust towards attorneys. I'm not sure why anyone would be distrustful of attorneys' motives. Where these concerns are not present, a justice may provide a summary explanation of a recusal decision. For example, Justice X took no part in the consideration or decision of this petition. And this is the Code of Conduct canon because of financial interest, or Justice Y took no part in consideration or decision because of prior government employment. So he's setting out some different examples of when that would be appropriate. And, a general statement of recusal makes sense. I can see how that would make sense. So if that were to happen, if one party had the majority in both the House and the Senate, yes. Again, it would just be like impeaching a president. So whoever's in power in the House and in the Senate, that's what would happen. Again, it comes down to why it's so important to vote for, whomever, whichever side. But voting is so important because that level of power is enormous. Yes, and I think, that's a good question. We ask these questions because we're concerned. We're saying to the U.S. Supreme Court, hey, we've got some concerns. And this has been brought up repeatedly. I would say it started probably about 2010. We really started asking these questions of where's our judicial code of ethics. So this isn't necessarily something brand new. It's just definitely getting a lot more press and seems to be a lot more pressing right now for a lot of reasons. And that, that makes sense. It would be interesting. We have had one justice impeached in our history. Samuel Clemens, I believe he was actually impeached. And that was, I think, an issue. He took bribes, if memory serves. But yes, that's not good. That's no good. A justice also may provide an extended explanation for any decision to recuse or not to recuse. And he's citing the Microsoft Core case, which was a 2000 case decided by Chief Justice Rehnquist. So this idea of recusal or not recusal has been established in some case law. So it's been supported. If you look at the case, the way that the Chief Justice is looking at it here. A word is necessary concerning security. Now, this is a really big issue with the justices right now that have been they've really been talking about, all of the justices have been talking about how heightened security is an issue at this point. And, perhaps in the past, this hasn't been as big of an issue. Although it seems most of the protests in the past have been on the steps of the Supreme Court justices' building, so in front of the Supreme Court rather than at their personal residences. But now we have groups of people protesting outside of the homes of the different justices. And this is something that's relatively new. Having a few people here and there is one thing, but actually having whole groups of people. And I think with social media and being able to kind of corral groups of people as well, this is just something that has now become an issue that needs to be addressed. And the court has repeatedly talked about that to Congress. Samuel Chase, thank you. I wonder who Samuel Clemens is. Who am I thinking about? Yes. So judges at all levels face increased threats to personal safety. These threats are magnified with respect to members of the Supreme Court, given the higher profile of the matters they address. True. Recent episodes confirm that such dangers are not merely hypothetical. Yep. Security issues are addressed by the Supreme Court police, United States Marshals, state and local law enforcement, and other authorities. Matters considered here concerning issues such as travel, accommodations, and disclosure may at times have to take into account security guidance. Now, the reason he's adding this, I think, could be because there was a situation where Justice Alito had been asked to speak at a location at a time where he felt it was not safe for him to travel because of security concerns. So that may be why that was brought in. But we've had some huge security issues. Thank you, Mark Twain. Yes, of course. Oh, no, he was not Samuel Chase. No, he certainly was not. Although they do look similar, I believe. I may have just made that up. Too much in my brain. But anyway, back to security. Yeah, there's security issues. I think in particular, Justice Kavanaugh has especially had some problems with people coming to his home and making their thoughts known to him. So that, that's an ongoing concern for the court and something that really hasn't been looked into that heavily in the past. And if you'll remember, even Justice Thomas, who came in 1991, and it was a very controversial set of circumstances for him joining the court, was not dealing with these kinds of security issues at that time. And it's just, kind of the nature of how things are these days, as opposed to way, way back in the 90s, which was last century, the late 1900s. So here is, next up, we've got a list of the resources that he's citing to kind of back up what he's saying. So he added on to this letter this list of authorities that he's using. Justice Alito is the most annoying justice on the court. Well, ethically, I'm not allowed to speak regarding a sitting justice, but he's an interesting way of looking at things. How's that? That will be my only ethical statement. So, minus the yes. Oh, Hamilton has some very good points, actually. I think the Hamilton, what is especially interesting to me is the huge fight between John Adams and Thomas Jefferson, where Aaron Burr actually got second place in the presidential election. And that led to the change of the Electoral College. Now, if you want to talk about a judge or a president that absolutely stacked the courts, that would have to be John Adams. I mean, because we were at the beginning of designing the courts, and so they were basically coming up from scratch. So the power he and Congress had together regarding the judiciary branch was just almost unlimited at the time. So, yes, I don't know. I think Justice Alito is true to himself, which is good, but, he's got a few bits and pieces here and there where I'm like, okay, that's a good point, but it can be difficult to read his decisions. And I think he's, especially when he's asking questions in oral arguments, some of his questions are just very offensive, honestly. I mean, they're prejudicial. And you can clearly see where his personal discriminations lie if you listen to him asking questions during oral arguments. And that's something that just kind of pushes my buttons a little bit when a judge is asking questions in a manner that is so clearly discriminatory. It's like, can you at least hide it for the purposes of oral arguments? That would be great. But nope, no hiding there. So here we go. Ethics in Government Act. This was the act I was talking about earlier that sets out in 1978 by Congress the ethical obligations of different parts of the government. So I won't go through this line by line, but a very tall, scary butler named, oh my God. Well, interesting. He probably was with Samuel Clemens too. As we go through this, I just want to explain overall that this act was passed by Congress in 1978 and gives a broad overview of the ethical financial disclosures that everyone's been talking about so much. So you can look this up online, this exact Ethics Act, and it would be Ethics in Government Act of 1978. And it goes into why you have to file certain things, what you need to file for disclosures when it comes to transparency for different government people. And there's a lot, like what goes into the report that you have to file. Now, Justice Thomas kind of had his response to the initial story that broke regarding some of the gains that he had received. He had said he didn't realize that he needed to disclose those kinds of things. And he had spoken to a few other people who had said he didn't have to. And when you look at the requirements listed here in how to fill out the reports, I mean, it's a mess. It's a lot. This is that red tape that if I had to fill this out every single year, this was bonkers. I have my own things that I have to fill out ethically for my own practice, and I can understand that, but this is a lot. That's not an excuse. It's just, those are just facts. It's a lot. There are so many subsections in here on so many things regarding this transparency issue. The point of it is that Congress was pretty serious. They really wanted this transparency put into place. Now, with Justice Thomas, one of his biggest arguments was that he took a loss on this property that his mother was living on. He took a loss as his portion of it. And because of that, he didn't realize he needed to disclose it, because under these numbers, he didn't think he had to. But he did. And so he came back and said, whoops, I screwed up my report. I will amend it. And so that was his response to that fact. So I would just say, if you are going through this, and this is section 102 of this act, that there really are a lot of details. But on the other hand, with the amount of brain power that's on the U.S. Supreme Court, it seems like they would be able to figure out a way to properly file their papers. And again, don't get me wrong, there have been justices in the past that have had to amend their reports. I believe Justice Ginsburg actually had to amend her report a couple of times. So I'm not trying to single anyone in particular out, but his is probably, I would say monetarily, when I look back, it seems to be kind of that biggest question of, well, I didn't know what I was supposed to do, which is really why we're talking about this. How the public can have access to these reports. That was another concern that Chief Justice John Roberts had. How would that information negatively affect the cases that we hear if that information was too far, if it went too far outside of the realms of what is specified in this act? So what he's saying when he's going through at the end of his letter is he's saying, we're governed by this. We're governed by this statute. And because of that, because we follow that, that's enough. So let's go into what this act requires. The Ethics in Government Act requires judicial officers to file financial disclosure reports listing outside position agreements, non-investment income, reimbursement, gifts, liabilities, and investments. That's what accountants are for. Yes, they are. And I'm sure there are plenty that would absolutely be willing to help a justice out with that. Next, judicial officer means the Chief Justice of the United States, the Associate Justices of the Supreme Court, and the judges of the United States Courts of Appeals and United States District Courts. So he's acknowledging that this section of the Ethics Act applies to him and to the U.S. Supreme Court. He's acknowledging that. The reason I point this out, again, is this idea that Congress has no authority or power to talk about the ethics for the U.S. Supreme Court because of this separation of powers question. So what I would say is he's acknowledging Congress has passed a law specifically regarding the administrative portion of the U.S. Supreme Court and that he follows that law. So this idea that the separation of powers is an issue is not really meshing properly with his own words and his own conduct, in my opinion, as someone who studies the Constitution. The Judicial Conference administers the statute in the cases of judicial officers and has delegated that authority to the Committee on Financial Disclosure. The Courthouse Ethics and Transparency Act also requires judicial officers to file periodic transaction reports reflecting transactions in stocks, bonds, commodities, futures, and other forms of securities, in addition to annual financial disclosure, and that the administrative office of the U.S. courts makes such reports publicly available. The Judicial Ethics Act also places limits on outside earned income, honoraria, and employment. And yet again, acknowledging that he is saying Congress, again, passed this act and we comply with this act. Well, there is only one legal financial instrument. I'm not sure what you mean by that. There's never any one of anything. So I'm not sure exactly what you mean. Too many acts and too many papers. Well, that's the legal field for you. That's just absolutely what we do. We are just all about the rules and the acts. That's kind of what we do. So the Judicial Conference has adopted regulations for lower court federal judges relating to outside earned income, honorary, and employment. And then he's talking again about the lower courts. The justices comply with the substance of those regulations. And this was a Supreme Court resolution in 1991. So here he's saying, okay, we're complying. So I think this is kind of a, I'm not sure about that. That should apply to Congress as well. And they don't. Yes, absolutely. And Congress does have something very similar. And this Ethics in Government Act is not just for judges. This applies to any government position. So persons required to file are not just our judges, but if you're in Congress, wherever you are going to be covered by this. In specific, we're talking about the president, vice president, officers and employees of the executive branch, and so on. So everybody's included. The Postmaster General doesn't get out of it, the director of the Office of Government Ethics, all of them. Everybody's included here within this act. Well, I think the fact that the justices may not personally handle their money, but they do make decisions regarding their money could be a valid question to ask. So I think whether they accept something to take on something because of how much money is involved or not is definitely a decision that justices make. Now, one of the questions that was brought up during the Senate Judiciary hearing was that there was an auction for something that Justice Ginsburg had signed, and it had gained $1 million. Now, she didn't get the $1 million. That money was distributed, but again, it was awarded to her essentially to give to, whomever was the appropriate beneficiary of it. So, that was just gifted to her. Now, did she decide? No, but that's $1 million. I mean, that's pretty significant money to have involved. So it's a problematic for justices who come from wealthy backgrounds. So I guess I would ask you, which justice do we have that is not from a wealthy background? I would ask you that question. And I would say, cautiously when you look into the background of Justice Thomas for answering that. Now we've got the federal gift statute. No officer of the judicial branch shall solicit or accept anything of value from a person seeking official action from or doing business with the individual's employing entity or whose interests may be substantially affected by the performance or non-performance of the individual official's duties. This specific statute was what I had spoken about at the very, very beginning of the live, where we've got law set out regarding just in regards to gifts themselves. And there are a lot of rules that are set out regarding gifts, a lot. So this issue time and time again is hit on over and over and over again on what's appropriate for gifts and what's not. Now, what you might know in some of your state legislatures is that they have set out a gift limit for different elected officials, and they may have also set out different limits for judicial people as well for how much can be given. When I worked in my state's House of Representatives, I think the gift max that could be given to any representative was $3 at the time. And that's not because it was in the 1920s, thank you very much, but it was because it had to be such a small amount. So when I was working there, I was working for a representative and had wanted to get a little thank you present, and it had to be under $3. And so what a lot of the interns and I would do would be just go to the dollar store and go and buy 2 $1 items and give them as thank yous to make sure that we met that $3 requirement. So it can be very, very strict. So these ideas of being careful about gifts are just very well rooted within the government structure. So it's not something new. It's not something that's like, oh, we should take a look at it. No, it's been something that is integral to the system for a long time. Now, whether or not there's a way around the rules, that's a different question. But the rules themselves have been in place for quite a while. Some corporate jobs restrict gifts to around $25. Sure, that makes sense. That I can see that. Wealth has no issue. Whatever disposable income falls under strict scrutiny. Yes. I wouldn't say. Right. Yep. I'm just glancing quick at your comments. You all have such great comments. I'm so thankful. It's really fun to have a discussion with people who are joining me. So this is a reference guide to gifts when it comes to giving gifts to any of the judges. And this is from a desk book set out in June of 2020. And it's, again, you can easily find this online, and it goes through all of the different, even like the Army gift program, the Navy program, prohibited sources for punitive prohibition on gifts. So there are a lot of rules and regulations regarding gifts just across the board. And I think here they even set out some exceptions and then amount limits and so on. So we have this structure already put into place. It's just a matter of how it's implemented and if everybody knows what it means. I find, and perhaps it's just me, but I find it a bit disheartening when a justice comes out and says, well, I didn't know how to properly file this, when it's a justice's job to read the fine print on everything. So on the one hand, I can understand why that would be difficult. On the other hand, I'm saying, that's your job. That's what you're professionally trained to do. So I see both sides. I can see both sides on that. I don't know. I really don't know. I doubt it. I doubt they would have any effect. But questions about judicial ethics are best addressed to the administrative office. Yes, and I will be getting into them. They are coming up next. I'm giving you Chief Justice Roberts' thoughts first, and then I will go directly into the administrative office. So here's our statutes. They're cited here, as well as I pulled these out for you for those procedures that they're talking about. This is the same statute that he's referring to here for foreign gifts and decorations. And this is the act that covers gifts again. Honorary club memberships. Judicial officers may not accept a gift of an honorary club membership valued at over $50 per calendar year. That's another requirement that's been set out that they agree is absolutely fine. And then he goes into the federal recusal statute. Now, again, this was set out. This is a statute passed by Congress setting parameters for recusal standards for judges and justices of the United States. So the Chief Justice has stated that the limits of Congress's power to require recusal have never been tested. So rather than saying, okay, here's the U.S. Code statute passed by Congress that we're going to follow, what Chief Justice Roberts seems to be saying is, yeah, you passed this, but, no one's really raised the issue yet of how far that actually can go. And so I'm wondering if he's kind of giving a red flag and saying, if you push us, we won't voluntarily follow this. I don't know. I'm just completely guessing on that. But that's some pretty bold language to say the limits of Congress's power to require recusal has never been tested. So I don't know. Those kind of seem like a close shot there. But the justices follow the same general principles as other federal judges, but the application of those principles can differ due to the unique circumstances of the Supreme Court. First, there's no higher court to review the justices' recusal decisions. Second, because recused justices cannot be replaced, a justice cannot withdraw from a case as a matter of convenience or simply to avoid controversy. In 1993, a statement of recusal policy addressed recusal issues where members of a justice's family were practicing attorneys. So he's citing and saying there has been some law set out and we voluntarily choose to follow that, but it's not been tested, the limits of that. So I don't know, that's a little bit precarious, if you ask me. Ethical issues should be within the realm of the Supreme Court. Right, but we do have a separation of powers, which means each branch has to be kept in check. And that was how the Constitution was written. And it's specified even within Article 1 that Congress has some powers over the judicial branch. So that there can't be a final say at the Supreme Court level when it comes to the procedural issues. Now, when it comes to their decisions, absolutely. They absolutely have the final say. That's how it is. You win some, you lose some. That is just how it is. So the substantive law that they are deciding with their opinions, absolutely. Absolutely. But when it comes to the actual procedural or administrative process of the United States Supreme Court, it could be argued that Congress was given that check to keep the Supreme Court in check. It could be argued that way. I hate to have to block anybody, but sometimes things just go a little too far for me. So unfortunately, I just try to keep things on the fact path as best as possible. It's okay to have a difference of opinions, but false basic facts is kind of outside of my scope of what I'm able to handle. So here we go. Code of Conduct for U.S. Judges. Code of Conduct for U.S. Judges applies by its terms only to lower court federal judges. That's pretty clear. Code of Conduct here. He says they're for lower court judges. And, his rationale could, again, even though they're appointed for life, they're a bit of a different animal than the U.S. Supreme Court, which is unique. There's only 9 of them. There's no one that can step in. There's across the United States, we have so many federal judges as opposed to just the 9 in the U.S. Supreme Court. So it is unique to some degree. And he's saying here, this code of conduct is not going to be applicable to us. We are a different animal. IPO purchases and discussions with prospective private employers. So I don't want to spend much time on this either. I feel like this is a bit of a red herring myself, but that's just my thought. The Stop Trading on Congressional Knowledge Act, which was set out in 2012, provides that justices and lower court federal judges may not purchase securities that are the subject of an initial public offering in any manner other than is available to members of the public generally. The Act also provides that justices and lower court judges who are negotiating agreements with private entities for post-judicial employment or compensation or who have made such agreements must file statements with the individual supervising ethics office within 3 days and include the name of that private entity or entities involved in such negotiations or agreement and the date of such negotiation or agreements commenced. The justices follow that statute. What I think is good to note again is that he's saying, hey, we've got another statute here that is requiring us to do something, and we are complying with that statute. So again, he's saying Congress has set out a rule and we're following that rule, which, begs the question that if you're saying Congress has no power here, then why are you following these acts that they have set out as rules? So I just think it's a good question to ask. I'm not saying whether it's right or wrong. I'm just saying I think it's a valid question that he's claiming in his own language that they follow these statutes, but yet is also claiming that Congress has no authority or that the limits of congressional power has not been challenged. So just interesting thought to have when we're dealing with these kinds of questions. So that takes us then to the end of the letter Chief Justice Roberts sent to the Senate Judiciary Committee when it came to whether or not he was going to testify. So he said, no, I'm not going to testify, and here are the reasons why. I don't have to. That's pretty much it. I don't have to. We follow congressional statutes that we like, that we're okay with. We follow them. And so that's more than what we should technically have to do, is kind of how that could be taken technically. If anyone is interested in that very last piece, this is what it is. Public Law 112 through 105 regarding the Stop Trading on Congressional Knowledge Act there, if you wanted to pull that information up. Again, I feel like this is a bit of a red herring, but, you know, it is what it is. He just doesn't want to be accountable for their actions that restrict their, well, yeah, I mean, there's just a lot of, yeah, they're not above the law. And that's true. I think that's very, very true. Yeah, that they really aren't. And I think his explanation, or this level that he's putting the court at, I think it's like, I get it. You are the Supreme Court, but your rulings are untouchable, but your administering of the Supreme Court is not. I mean, it is. We can regulate that. And that's always been the case. And even if you go back to James Madison, when they were originally designing the government itself, he specifically said every single branch needs to have a check. So that was very important. And I mean, it's specified out there. So I think this idea that there's no way to check the U.S. Supreme Court goes against the intention of the Constitution, which Chief Justice Roberts is all about, that language of the Constitution. So I guess I would encourage him maybe to look to the original drafter's intent. So that takes us to, and I think I'm carefully staying within my legal ethics regarding those kinds of questions, but that takes us then to a very interesting piece that, you know, we have to talk about, which is the questions asked of the legal counsel. And this is more of the administrative look, the people who are enforcing those administrative rules. Well, hello, welcome to my new people joining me. Thank you for coming tonight. So we first have this letter from July 12th of 2021. And there were some questions posed to the Administrative Legal Counsel of the Supreme Court. So you can see Supreme Court of the United States here, and this is the legal office. So this is the office that deals with their administrative questions. And that's what this letter is about. So let me go through what is being asked of them here. All of this kind of came about because of a letter that was written to them from the Judiciary Committee way back in the day. So several years ago, there were a lot of questions on this personal hospitality issue, along with what exactly the ethical parameters were, because they're not really that clear. And so when those questions were asked of the legal counsel's office, they sent back two letters. And this first letter is in July of 2021, and the second one is in April of 2022. So here we go. Thank you for your letter regarding the financial disclosure requirements for the justices. So this language is specifically coming from the legal office of the Supreme Court of the United States. So, let's see, Skelly Coast, are you here? Good to see you. If you ever want to join any of my lives, you'll have to specifically let me know. A lot of times they just suggest, and I never know if people are actually asking or if TikTok is just suggesting. So let me know, but good to see you. Now, as we go through this, he's specifically going into this language that's saying the court appreciates the opportunity to hear your perspective on these and other issues facing the judiciary and the rest of the government. Because your queries concern the court's ethics, policies, and practices, the clerk of court has asked me to respond. This is again 2021. Before turning to the specific questions included in your letter, it's important to clarify key points concerning financial disclosure rules, specifically the Ethics in Government Act of 1978, which I had been speaking about earlier. So they're specifically asking for clarification on this Ethics Act. So it directs the justices and other federal judges to make financial disclosures, and it grants to the Judicial Conference the authority to issue implementing regulations for the judiciary. The justices follow the financial disclosure regulations issued by the Judicial Conference's Committee on Financial Disclosure. Now that takes us back to this committee that we had discussed before that put together the conduct for our federal judges. So when it comes to the financial disclosures, the legal office is saying that they are following the Judicial Conference Committee's rules on the financial disclosure. As a result, the justices file exactly the same types of report that other federal judges do, and those reports are made available to the public in the same way that the reports from other federal judges are. So we have this letter where Chief Justice Roberts is saying we don't have to comply with the same ethical rules as our federal judges. We don't have to. But then the legal counsel for the Supreme Court is saying, but when it comes to financial disclosures, they do follow those federal judges' rules. Now, it seems like they don't have to follow those rules, that they are choosing to follow those rules. So there's nothing in place that's requiring it of them. So with this important point in mind, I can provide the following responses to the questions posed in your letter. And this was a letter that was written by by the Senate Judiciary Committee, the chair of the committee. So let me see if I have his letter. If you could see my desk right now, it is a mess. Again, this is when I wish I had my paralegal with me tonight, but I don't, so you'll have to just bear with me for a moment as I dig through my stacks of papers. And here it is. All right, here we go. I got it. It's a little wrinkled, but here it is. So this is the letter from the U.S. Senate. And he's writing and asking for clarifications on all of these different ethical questions. Okay, so I'm going to be referring in this letter from the legal counsel to this original letter that was written by the Senate Judiciary Subcommittee. Okay, that's where it's coming from. So back we go. This is what he wrote in his letter. What plans, if any, does the court have to adopt a code of ethics or to bring its gift, travel, and hospitality restrictions and disclosure policies in line with those of the executive branch in Congress? And again, at the very beginning, I did talk about how both branches of Congress, along with the executive branch, both houses in Congress, and the executive branch have ethical rules that they have set out. What are we reading? This is from a statement or a letter from the legal office of the U.S. Supreme Court answering questions about the U.S. Supreme Court's ethical policies that was written in 2021. There are two letters that were sent to the Senate Judiciary Committee. So here we go. If it has no such plans, what justifies the court having a lower disclosure standard than other branches of the government? So with that, the answer from legal counsel was just as the justices follow the same financial disclosure rules that are applicable to other federal judges, so too do they comply with the same restrictions on gift and outside activities that are applicable to the rest of the federal judiciary. The Judicial Conference, the judicial branch's policy-making body, consisting of circuit and district judges from around the country, has developed comprehensive policies on those matters tailored to the unique characteristics of the judicial branch. While the Judicial Conference regulations on gifts and the Judicial Conference regulation on outside earned income, honoraria, and outside employment are not by their own terms applicable to the Supreme Court, the justices have complied with them. This is saying we're following the rules. Do we have to? No, we don't have to follow them necessarily, but we're choosing to. Under the regulations, the justices may not accept gifts from those who seek official action from or do business with the court, with only limited exceptions. Judicial ethics principles also provide that recusal is appropriate when a justice has a financial interest in a party before the court. Yes, we complied with them. Trust us. Oh my goodness. Absolutely. Absolutely. Just take my word for it. The justices also rely upon the Code of Conduct for United States judges in evaluating ethical issues more broadly, as the Chief Justice explained in his 2011 year-end report on the federal judiciary. 2011, so that was a while ago, with specific reference to the needs and obligations of the federal judiciary. But because the Code of Conduct is phrased in general terms, does not address all questions that the justices may face, they may also consult a variety of other sources in evaluating ethical issues, including the Constitution, federal statutes, judicial opinions, legislative and executive branch guidance, the justices' historical practices. What does that mean? The justices' historical practices. So they're relying on what other justices have done in the past? That's questionable. Because just because it was done in the past doesn't mean it was done correctly. So I'm going to just put a little asterisk there. Treatises, scholarly articles, state court guidance, and disciplinary decisions, and they may seek advice from the court's legal counsel, legal office, the Judicial Conference Committee on Codes of Conduct, or their colleagues. So that's their answer. So when the question was, well, what are you guys going to do about it? The answer was, well, nothing. We rely on all of these sources. So that's it. Yes, legal precedent. The Chief Justice only took to 2 cases when he explained the ethical responsibilities of the court. He only cited 2 cases in that. But it's an interesting way of looking at it. So that first question, do they have an ethics code? Well, they've kind of picked what they like and choose to follow. And anything else is just up to them to decide. Number 2, does the court or do the individual justices maintain records of emoluments in the nature of gifts, travel, hospitality, and reimbursements received by members of the court? Do such records include the dollar value and descriptions of the emoluments? Here's the response from counsel. The justices individually maintain records of gifts, reimbursements, and other financial information needed to prepare annual financial disclosure reports in accordance with the Foreign Gifts and Decorations Act, which I've already gone through earlier. The justices also make disclosures relating to the gifts, decorations from foreign governments. The court collects that information from the justices each year, provides relevant information to the Director of the Administrative Office of the United States Courts for inclusion in a single report relating to the federal judiciary. Disclosure rules under the Foreign Gifts and Decorations Act call for the description and value of the items to be listed. And again, that is all set out in the acts that I've been talking about earlier in the live. And really, it's 5 U.S. code and 10 U.S. code is really where a lot of the information. Yes, needed. Yes, absolutely. And that term needed, who gets to decide what that is? Well, the justices do, right? And so if the justices do, where's the accountability? It's a valid question. What steps does the court take to identify or prevent the justice's receipt of gifts, travel, or hospitality from those who may have business before the court? The rules noted above are well known to the court. Okay. The justices and their chamber staff take care to ensure that any items received are in full compliance with those rules. Okay, so they just, what steps do they take? Well, whatever steps that they would like to take is the steps that they take. Number 4, for purposes of the justice's disclosures, how does the court define the term personal hospitality that appears in the Ethics in Government Act, which I've spoken about before, exempting from disclosure any gifts in the form of food, lodging, or entertainment received as personal hospitality? The term personal hospitality of any individual is defined by statute as hospitality extended for a non-business purpose by an individual, not a corporation or an organization. This seems a little bit aggressive, in my opinion, from the language, but, maybe it's not. At the personal residence of that individual or his family, or on the property or facilities owned by that individual or his family. Judicial policy is also cited here. Personal hospitality of any individual's hospitality extended for a non-business purpose. And so he's going back in here. The justices may also look to the executive and legislative branch interpretations of financial disclosure rules in individual cases. Okay. Right. I took a plane transportation. Yes, quite. It does seem that way. Oh my goodness. What plans, if any, does the court have to make the justice's financial disclosure reports more accessible to the public? Great question. As noted above, the justice's financial disclosure reports are available to the public in the same way that those of other federal judges are. They are also routinely posted on a variety of internet sites shortly after they become available for public view. All right. So that's it. So are there any plans? Nope. We've made them available, and how you choose to take care of that is up to you, is kind of what's being said here. Thank you again for your letter. I hope and trust that the information provided here sheds additional light on the many statutes, rules, and regulations applicable to and relied upon by the justices on these issues. So they're relied upon, but that's about the extent of it. So that's what we have from the legal counsel of the U.S. Supreme Court in response to the Senate Judiciary Committee's request. This was July of 2021. Now, we can go to a second letter, Administrative Office of the United States Courts. And I think this one is incredibly helpful because it takes us really into the framework that we're dealing with for the Judicial Committee when they're talking about exactly this personal hospitality question. Here we go. I'm writing on behalf of the Chief Judges of the U.S. Courts of Appeal and the chairs of the committees on the Code of Conduct and Committee on Financial Disclosure in response to your letter dated August of 2021. Relating to the exclusion of personal hospitality from the disclosure requirements under the Ethics in Government Act, the judiciary appreciates the opportunity to hear your perspective on these issues. I apologize for the delay in responding. So this is August 30th, and this is April. So, okay. Our answers to your numbered questions are provided below. Many of your inquiries fall under the jurisdiction of the Committee of Financial Disclosure, which deals with financial disclosure reporting. The Committee on Codes of Conduct, on the other hand, primarily provides ethics advice to judges. Please be aware that these answers are dependent on the interplay between the judiciary's gift regulations and its financial disclosure reporting requirements. The gift regulations may prohibit the acceptance of a gift under many of the circumstances described, and therefore the financial disclosure reporting requirements would only become relevant if those situations in which gifts were permitted in the first instance. Interesting. So the first question, and they all say it's okay. Oh, thank goodness. I'm glad. General scope of personal hospitality. Is hospitality to a judge from any person subject to exemption from reporting, so long as the person has invited the judge to receive the hospitality at any property the person owns? So let's talk about the Ethics in Government Act. It requires that a financial disclosure filer must report the information relating to gifts of more than minimal value, $415, received from any source other than the relative of the reporting individual during the preceding calendar year, except that any food, lodging, or entertainment received as personal hospitality of an individual need not be reported. Okay, so they're just quoting the statute line back. They're not really going into what it means here. It's not correct to state that a judge need not report hospitality from any person as long as the judge receives the hospitality at any property that a person owns. At a minimum, the exclusion from reporting applies only if the hospitality was extended for a non-business purpose. And there may be other limitations on the exception as well. All right, that's not very clear. Does anyone else want to chime in? What are your thoughts on that? That's a pretty interesting explanation of personal hospitality clarification. So personal hospitality of commercial properties. Is a judicial officer permitted to decline to disclose personal hospitality received at a commercial property? And B, for example, if the owner of a commercial resort has invited the judge to the resort, which guests ordinarily pay to visit, may the judge treat the hospitality as personal? That's a great question. I've requested that the Committee on Financial Disclosure provide guidance on whether personal hospitality may encompass hospitality extended at a commercial property, such as a resort. Judicial conference regulations provide that any food, lodging, or entertainment received as a personal hospitality of any individual need not be reported. Okay, and that's according to the Guide to Judiciary Policy. Now, if we remember, Chief Justice Roberts' letter said that this policy, some parts of it they follow by choice and some parts they don't. Section 170 of those regulations defines personal hospitality as defined in the statute, that is, extended for a non-business purpose by an individual, not a corporation or an organization, at the personal residence. This, again, is quoting that same judiciary policy. I've asked the committee to provide guidance on whether property or facilities owned by that individual or his family could include commercial property. The committee will be addressing this issue at its next semi-annual meeting. Well, that's not very helpful at all. So we have questions with no answers, and this was over a year ago. Where are the answers? That's a great, valid question. And more. So again, this idea of personal hospitality from persons not known to the judge goes on. There has to be a courtship. Oh, goodness. Oh, goodness. So he's going on to say he's requested that these things be defined and clarified in the Committee on Financial Disclosure. Next, we go down to solicitation of personal hospitality. May judges directly or indirectly solicit invitations from owners of commercial properties and then claim exemption from the disclosure on grounds that the owner invited the judge to a property the person owns? Would the solicitation of such an invitation to a commercial property be reportable? That's an excellent question. And that's a really good question. The judiciary's gift regulations state that a judicial officer or employee is not permitted to solicit a gift from any person who's seeking official action. Okay, that's not really an answer. Or doing business with the court, or from any person whose interests may be substantially affected by the performance or non-performance of the judicial officer or employee's official duties. And we're going back into that judicial policy. So what I'm gathering here is, and I've not spent a lot of time on this document, and I don't think anybody really should, is that he's pulling the language specifically out of this judicial policy and just kind of spitting it back to the Judiciary Committee and just saying, here's the language. What does it mean? I don't know. We're asking the committee. So that's interesting. And that takes us down here to number 5. Again, more of this idea of solicitation of personal hospitality from persons not known to the judge. We are aware of no obligation to report solicitations of hospitality, which is interesting because up here he said we don't know. And so here he's saying, wait, we don't have any obligation. So even within this letter, he's kind of going back and forth. So, third-party reimbursement. Regarding the reporting of gifts given for which the offerer has been reimbursed by a third party, each financial disclosure report must contain the identity of the source of the gift, a brief description, and the value of all gifts that meet the threshold for reporting and for which no exclusions apply. Irrespective of whether personal hospitality includes hospitality furnished at a commercial property, personal hospitality must be extended for a non-business purpose by an individual, not a corporation or organization. And that, again, is a citation out of the Ethics Act here. So if a third party reimburses the host for costs, then the hospitality may not have been extended for a non-business purpose. Now, this may not means they don't know. It could have been, but it might not have been. So that's... Who's this person again? Let's double check this person. Who do we have here? Miss Mousecoft. Well, Miss Mousecoft is saying a lot about nothing, in my humble opinion. Maybe it's because it's getting late, but this is absolutely no guidance whatsoever, actually. Number 7, acceptance and disclosure of gifts from those seeking official action from or doing business with the court. Does the judicial branch's prohibition on acceptance of gifts from persons who are seeking official action from or doing business with the court extend to gifts in the form of invitations to property? Yeah, I'm feeling that way. I'm really getting to the point where I thought my frustration level would fizzle out a little bit, but it alas is not fizzling, and that's saying something, because it doesn't take much for me to de-escalate. But this letter is absolutely bonkers. It's not answering any of the questions. It's only citing this judicial policy that may or may not be used by the Supreme Court, depending on how they're feeling. And it's citing a statute language that is the exact question. And she's citing it just back at the question. So I guess for me, I would say this particular letter is almost completely useless. And it's sent to all of these people on the Judiciary Committee. So, and as I had suspected, but had hoped was incorrect, I had really hoped that the legal counsel for the U.S. Supreme Court would actually have something valuable to add to the discussion, but they do not. They really do not, other than the fact that they're adding that the Supreme Court can do what it wants and how it wants to do it. And any other kind of regulation is just at the whim of the Supreme Court, which, in my opinion, looking at the Constitution and how the different branches are set up, goes against the intent behind the original drafters. In my humble opinion, as someone who spends a lot of time with the Constitution. So that brings me to several questions. I've got several questions that I think are worth exploring. And it comes again back to this idea that we have our other branches of government with their ethics requirements. We have our legislative branch, we have the Senate, we have the executive branch. They all have to have ethical rules. Now, whether they follow them or not, that's a different question, but the rules are still there. We have our ethical rules for our federal courts, and those ethical rules are set out by the Judicial Conference of the United States. So these people, as of July of 2023, these are the people that make up this committee, and they're the ones writing out all of the rules for all of the judicial courts at the federal level. Now, some of these rules, the U.S. Supreme Court said maybe we'll follow them, maybe we won't, it depends. But they do cover all of these judges, all of our circuit courts. But there is no specific, here's the Senate Ethics Manual, there's no specific set of guidelines in the executive branch for what the U.S. Supreme Court is supposed to do. And again, this argument from Chief Justice Roberts at the very beginning of his letter is, I shouldn't have to come in to testify as the Chief Justice. So I shouldn't have to come in and testify in front of the Senate. And I can understand. And also saying that Congress doesn't really have any authority, which I would argue is completely incorrect. So this is a really frustrating situation. Now, politically, the arguments are overwhelmingly hostile. And one side is saying that there's an agenda being put forward because we have a conservative Supreme Court. And because of that, they're trying to intervene and somehow ruin the reputation or the authority of the U.S. Supreme Court because it's a conservative court. But if you look to the history, there have been a lot of very conservative courts over the 230 years. So I'm not really sure how strong that argument is. But when they're arguing about it in Congress, one side is saying the other side doesn't care about what's happening to the court. They just don't like that it's conservative. The other side, part of the other side is saying, we just want ethical rules for everybody across the board, all of the Supreme Court justices, and have for a long time. And another faction is saying the Supreme Court is run out of control. And that's because of some very controversial decisions that were made in pulling in Justice Gorsuch and so on. So there are a lot of arguments, and the debates seem to be very ugly. And if you look at it politically, I can see that. But if you're looking just at the law itself, if you're looking to the rules, move to the left, there you go. If you're looking to the rules, Chief Justice Roberts is saying we have rules that we follow, and we follow. And if the only rule that he follows, that he claims to follow repeatedly, is the Ethics Act, which we've been talking about quite a bit tonight. And again, that was established by Congress and set out for all government employees to follow. And if that's the act that he says we're supposed to follow, that's a congressional act, right? So doesn't that mean that Congress then has the authority to deal with the administrative procedural aspects of the U.S. Supreme Court? I don't know. I think so. In my opinion, I think Congress has some authority. I don't think Congress should ever be a part of the decision-making or the law set out by the U.S. Supreme Court, but Congress has specifically, we have the very first act of 1789, the Judicial Act, that set out the size of the U.S. Supreme Court and what we needed for a quorum. Those rules were set by Congress back in 1789. So I guess it frustrates me as someone who has studied this division of the three branches and the checks and balances, that one branch is saying absolutely no check should be in place because we are at the top of the food chain, when in fact it specifies specifically in the Constitution that Congress has the authority to set out the rules and regulations for our federal courts, and the Supreme Court is just plopped down into Section 1, and there's no information on the administration of it. But yet in the same sentence where it establishes the judicial power of the United States in a Supreme Court and in such inferior courts, in the same sentence is the word Congress. So, I guess to me it's difficult to try to say that the Supreme Court under Article 3 is at the absolute top of the food chain, because they're supposed to be three different branches. and checking each one. So I don't know. I think the argument can be made. I think a lot of constitutional law people kind of have fallen in the same group where we're just saying, what? What are you doing? Chief Justice Roberts, you already have the size of the court because of Congress. You already have a quorum because of Congress. You already have to do financial disclosures because of Congress. So for Congress to ask you to set your own rules of ethics, is that an administrative procedural question covered by the role of Congress in the Constitution? Or is that somehow affecting their decisions that they're making? I think it's a good question. I'm not sure how asking them to write their own rules of ethics is negatively affecting how they make their decisions. So if anyone knows the answer to that, please enlighten me. I would be very interested to know, because I am struggling with that a little bit. And again, the Senate bill that was suggested regarding how they went about recusing themselves, how they went about making it public, how they go about I think the bill actually included being able to make complaints about the Supreme Court for certain reasons. I get it. There was a lot of extraneous information in the bill. I'm not sure that I'm not in particular fan of the bill as it was written myself, but the part where it's asking the court to write some rules for ethical conduct for itself, absolutely. Absolutely, I am in support of that. And how it gets implemented, I think, could be done the same way that the financial disclosures piece of the lower court's requirement that they voluntarily follow is implemented. That would be my suggestion if I was to go and make a proposal. No rules exist. There are rules, but I think the interpretation of those rules continues to be an ongoing issue. Ketanji Brown wouldn't be allowed to vote on anything if there were rules like that. How so? Joe Hollop. I'm not sure what you mean about that. And Ruth would say, F off, mind your own business. Perhaps she would have. But, Justice Ginsburg also has made some very questionable ethical decisions. And because there is no set of specific rules for the U.S. Supreme Court that can be clearly defined. We have this general 1978 ethics rule for all government employees, but that's it. We don't have anything more than that. So when she was disclosing various things that she did, it was absolutely fine according to her interpretation of it. But it doesn't necessarily mean that that's how it should continue to be. And perhaps by looking at all of the justices, we can see that they all need some assistance with this act itself. Ethics in government does govern them, but they are not really sure exactly what it means. Do you know if they need to be unanimous in conference to appoint an ethics officer with SCOTUS? I do not know if that's actually required by their rules, but I would believe that they would choose that they would choose to have unanimous agreement. And the reason is because there was unanimous agreement on this letter Chief Justice Roberts wrote to the Senate Judiciary Committee. I think they can come to a unanimous agreement on this issue. And that would also give credibility and authority to the position that they come out with. And they really need that. We're not in a position now where we are getting landmark cases by unanimous court supporting landmark constitutional principles. That we don't have that right now. We have had that in the past, but currently we just don't have that. And that's very unusual because that goes to show that there's a bit of a crack. And I wouldn't say it's because there's no reason to be relied upon. The court is still reliable, but I'm saying that there are a lot of disagreements. This is one thing they would really need to come out unanimously on, in my opinion. So SCOTUS is saying they have no rules. No, they're saying they have rules. These are the rules, the Ethics in Government, 1978. So the rules that they're saying are the rules that apply to all federal government employees. And some of the rules, just some of them, and only because they chose it, follow some of the rules that the federal courts have to follow. And it's completely based off of what they're choosing. We need to act like France. I'm not sure. France is having some issues themselves. Use the same rules that apply to Congress as a start. Well, that's a valid point, and Congress does have some interesting rules, but they're also unique bodies. And the Senate has its own ethics rules. The House has their own ethical rules. And Congress itself has to follow the same rules that the Supreme Court is saying that they follow. And I think, too, what's interesting, if you look to Article 1 that sets out Congress specifically goes into, and let me see if I can find the exact language here. Let me see. Here we go. Each house may determine the rules of its proceedings, punish its members for disorderly behavior, and with the concurrence of 2/3, expel a member. So Section 5, Article 1, Section 5 sets out that Congress, both houses in Congress, have to set out these rules for procedure. And this is in a stark contrast, again, to Article 3, which just sets out there's supposed to be a Supreme Court. So there's nothing in here. Section 2 and 3 go into jurisdictional questions, but they don't go into the procedures set out for the Supreme Court. What they do is they say Congress may need to ordain and establish some courts. So congressional authority is hinted at here, but there's nothing else in there. They have one paragraph and nothing in there says specifically that they need to set out rules. Okay, sorry. Oh, I get so worked up about it. Let me make sure I can get everybody here. All right, right. If I could afford to go out, France is doing. They've got some interesting ideas for sure, and I think France and the United States are kind of similar timeline-wise when it comes to independence and this idea of, I'm going to use this trigger word, but a democracy. I know, nobody likes that word. Representative, constitutional, representative government, whatever people would like to call it. They are kind of in the same boat as us, so to speak. Yes, the disclosure, and that's it. The transparency is the issue that everyone is really talking about, is this idea that, if you're going to take gifts and so on, fine, but just disclose it so everybody knows, so that we don't have to have these kinds of issues, is really what the question is. Good thing you're not offering legal advice. No, I most certainly am not. That would be unethical. Unlike some, I actually follow my ethical rules. I have a question. Go for it. I care a lot. Sure, I can try to help as best as I can. You asked your magic 8-ball and it broke. Oh, you might want to get it repaired. Sometimes they can be very helpful. Oh, still like... Oh, right. Republic. Sure. Whatever you want to call it. it seems no matter which term I choose to call our government is somebody will be unhappy with. So, I refer to the entitlement to a Republican form of government, which is set out in the Constitution, but a Republican form is actually technically a democracy. But don't come for me. That's just what they say in the Book of Governments. So it's not me. That's not, well, a representative democracy, a constitutional representative republic of a democracy. Republic, yes. I don't know what, I don't know exactly how you want to call it. I try to use the legal definition, but that never seems to go over very well. So I think you all know what I mean by that. The type of government that we the people is. How about that? And you fill in the title yourself so that no one gets a democratic republic. Yeah, that's another one. But I don't want to trigger anybody. But you all know, well, that certainly isn't true. That's incredibly offensive to China, I would say. My goodness. No. That's incorrect. But yes, there are some. What I was talking about was the separation here, and that it was set out in the Constitution. I digress. Boy, I tell you, you guys are hopping tonight. That's fantastic. I love the questions. I absolutely love the questions. This is a huge issue. I think this is a very huge issue, and it's one of the things that has fascinated me when I first learned about the U.S. Supreme Court as a wee lass back in the covered wagon days was, well, who holds the Supreme Court in check? And I remember my teacher saying, the people, it's the people that keep the Supreme Court in check. So I think there's some understanding of that, but, I think there's lots of different ways to do it. I think at this point, Congress, I think we all would just like the Supreme Court to sit down, have some coffee or whatever people at that level of ego have and talk about, what should we have? Maybe even just the process of discussing what their ethical rules should be would be helpful for them. Just sitting down and making an outline of, well, how far should we go? How much of this do we want to do? Because I think that would be helpful. Because what I'm seeing and what I think everyone else is seeing from the letters that were given from their legal office is we've got, let me pull these back out. So the legal counsel for the U.S. Supreme Court, in answering these kinds of questions, it's just bologna sandwiches. There's nothing, there's no, I was going to say there's no meat to it. It's getting late. Goodness. Need to have some locks together. Yes. Yes. I think, I think does anybody remember, and I'm not trying to bring politics in, but does anyone remember, I can't remember the exact circumstances, but there was something early on in Obama's presidency where there was a big controversy, and so he called them together to play basketball and have a couple beers. Does anybody remember that situation? I remember thinking at the time how ridiculous that was. But sometimes I think maybe, that could be. And if you, the beer summit. Yes. And I'm not trying to advocate for any kind of alcohol usage. People need to drink responsibly and within the confines of the rules of the Constitution. But what I am saying is that I think coming together like that and just kind of having this, having this idea of let's just hash it out. Let's talk about it. Let's just talk about it, get everything out on the table, clean it up, make it into something that's workable. And, maybe that's my way of viewing things. But, if the Supreme Court could sit down, order some pizzas, and be like, okay, what are we going to do for ethics? And just would go around the room. There's some smart people there. They can figure out how to word this so that they could, make it so it works for them. But I think here what we have is this power struggle between the court saying, you can't tell us what to do. Congress saying well, somebody needs to hold you in accountability to you, holds you in check. And the Supreme Court saying, well, it's not going to be you, it's going to be us, and it's going to be on our terms. That just continues the fight, which I think is, the issue here. If we can't pull politics out of the Supreme Court, I think we've already seen the trouble that comes. So, I don't know. I guess yes, I wish that, and I have listened to so many debates on this, and I think it's incredibly interesting to watch that when we are debating the Constitution, the rules, and the Constitution, it's very interesting. But as soon as one side or the other throws in a political party or a triggering person, it's done. It's over. There's no more discussion. It's just, talking points that we've all heard over and over and over again. And it's frustrating. Tried to be fair, but the liberal side of him came out. Oh, come on now. Come on. Oh no. Oh dear. See, here I am trying to put the world back together again, and you're fighting me. Fair enough. These letters, this one in particular, which I think is the most important, honestly, you can look up Chief Justice Roberts' letter to the Committee of the Judiciary. So if you put that in, or you can put in Chief Justice Roberts' letter to the Honorable Durbin, he's the chair, this document will come up. You might have to click through Senator Durbin's, front page. I don't know exactly how it's been linked in there, but if you go through, you can find these letters yourself. And there's a ton more. There's a whole bunch more available. I just pulled out what I thought was relevant for the discussion. So the Supreme Court is the only thing that can manage it. Well, that's what they're saying. And I'm thinking, I guess if you look at it, I'm trying to see it from all sides, which is difficult. But if you look at it like if we were setting up a law firm or a business, we all come together and sit down and we write up our code of conduct. And it's the same for our, state ethics committee. We all come together and volunteer rules and debate and talk about it. And if the Chief Justice is saying that the federal court rules, ethics for the federal courts, don't work for them because they're unique, then why not make their own then? Set out their own rules. But that's not what it seems to be about. It seems to be about who has the power and control in this situation, as opposed to what's best ethically. And that's, of course, frustrating for everybody. It's like the teacher taking its source from students. Well, it could be, although I think they're all kind of, if you think about the quantity of legal rules and knowledge within the brains of the Supreme Court justices, if you pull that all together and you debate it as we're supposed to be, as we're taught to do in the legal field, even though it's adversarial, we hash out agreements, we mediate, we come to agreements. And I think it's possible, although I'm not sure. Maybe I'm living in a dream. Perhaps I'm living in it. Yeah, what can you do? And I think I've said this before too. Once you've tried a few homicide cases, not much gets to you anymore. Not much. No, Z21 Nitro. I think saying that any of the justices are lying would be not a proper statement if there's no evidence to back that up or any kind of true accusation of that. Then I wouldn't say there's any way to back that up. So I'm going to need you to calm down. Okay. I don't want to have to block you, Jackson, but I'm going to need you to calm down now, all right? So let's just do that. It's getting a little late. I'm getting a little loopy. You know, it's sad when you can predict the outcome of a case just by who appointed the judge. You know, you can say that, Bonefish, too. I get you. I hear what you're saying, absolutely. And in some situations, I think that's very true. But I think if you look at the cases from just the last 6 weeks, or 2 months, there have been some situations where it's like, what? How did Justice Thomas come down that way? Or how did Justice Kagan decide that? It's been relatively surprising and hard to really predict. I mean, you have some inclination, which I think is true for all justices, with the exception of Rehnquist and perhaps Warren. But other than that, I think we've got some idea, but I'm not sure that it's that closely held. No, I think there should, of course, be oversight. I think oversight needs to be set up. Absolutely. I agree. And I think and maybe I'm not saying it the best way, but I think the Supreme Court justices need to set out their rules, and part of those rules need to include the oversight procedures. So absolutely, oversight is important. I know, but oh my goodness. Oh goodness. Can they subpoena Roberts to testify if he won't go voluntarily? Well, subpoena is a court order, and the Senate has subpoena power. I'm not sure what that would do. That would be a mess. I cannot think of any situation where a justice has been subpoenaed to come in. I have no idea what would happen. I think I lost vision in my left eye just thinking about that possibility. I'm unwilling to acknowledge that would happen. Not the Supreme Court's job to decide what's ethical, just legal and constitutional. Well, true, but as legal people, as legal professionals, we're the ones that really set out our own legal ethics. All of the attorneys and the judges together, we all get together and we set out our rules for conduct and we agree on them. And so that's what I'm talking about. And I'm saying, rather than just saying they should completely follow the federal circuit court's rules, I'm saying, let's compromise. If you think the Supreme Court is so special, then make your own rules. But there has to be some rules, and within those rules need to be accountability. So, can you trade your sorcerer's ring for... I believe I don't want to have to declare anything when I next go in to talk about my finances, when I have to file my report every year. Left, huh? I'm not sure what you mean by that. Although it's getting late, so I might just be processing slowly. You'll have to clarify, but yes. Well, and I'm not saying anyone's saying anything wrong, but it's too late in the day for me to be fighting anybody. So that's really kind of, I like to give out a little warning shout if someone's being just a bit too aggressive and perhaps not realizing it. That's more of the mediator, moderator in me when I'm talking with people online. So, well, does anyone have any other great questions? He's saying, I'm a leftist? Oh my gosh. As if ethics has any relationship. Oh my gosh, the left eye. Oh, you're joking with me. Oh, thank goodness. I tell you, I get it. It's so hard to be right down the center, and I absolutely get that. But when I'm online, I am down the center, and I have liberal friends, conservative friends, and they both just jump all over me. They jump all over me on both sides. So I feel if I make both sides upset, I'm doing it right. So lost vision in your left eye. Yes, that is how unacceptable a subpoena would be. And it's not necessarily that they couldn't issue a subpoena. It's just one of the things that it's like, if we take it that far, are we going to be able to recover? And I'm not sure that we could. I mean, right now we've got this kind of dubious respect for each other, very dubious, but still, I mean, Chief Justice Roberts, he wrote a letter explaining his justification for why he wasn't going to appear at the committee. Now, the committee wasn't very happy about it, or the chair of the committee wasn't, but they're like, all right, fine. But if they were to take it to the next level with that subpoena and try to force his compliance in that way when they're already pushing back at any kind of congressional involvement, I cannot see how that could possibly turn out okay for anybody involved. They couldn't force him. Well, I mean, it's a good question. I don't know who would enforce it, and I suppose, I mean, a court does have a right can quash a subpoena, but they have to have a motion to quash. So who would bring a motion to quash in front of a judge for the subpoena that they're trying to quash? I mean, it's just like, blah. It's an explosion of legal implications and procedural issues that would just be very difficult. Yes, yeah, and I think whichever side you're on, I can see lots of different sides to all of these questions, but I have my own personal beliefs on things, but when I'm trying to just share information with people, I just don't find it useful to choose one side or the other. I feel like the information can kind of get tainted that way, in my opinion, and maybe that's not the best way to look at it, but he isn't being questioned about a particular behavior, but being questioned on general guidelines. Yes, and, I think those general guidelines questions, I would guess he's like, look, I've already answered this over and over again, and our legal counsel has already answered this over and over again, although this is pretty bad way of answering it, in my opinion. It's not very helpful, but, I think once you get somebody under oath, and anybody in the legal field knows this, all bets are off. They can ask you anything about anything. And when you testify, you open yourself up to cross-examination. And even if it's in a Senate hearing, so there's no way to control what kind of questions are going to come buzzing after you. And I think one of the best examples was when Robert Mueller was testifying and he was going into his investigation. And the way he answered those questions was like, oh my gosh. I mean, he was like a wizard, so to speak, because he was like, look, I'm not going to answer that. I don't have an answer, or I've already answered it, or why are you even asking me that? And I think Chief Justice Roberts is like, I really don't want to be put in that position. And, I can understand where he's coming from, but on the other hand, who's answering these questions? Because it's not their legal counsel. So, if you say quash 2 more times, it's going to start sounding like... All right, no more saying the Q wash word. Oh, it's illegal. Well, yes, I think, yes, Kevin E. Spears. Yeah, I agree. I think it would really be just a really bad road we would be starting down. Neutral dissemination of information. Yes, I think so. And, again, whatever people decide to do with the information, that's up to them. But to actually have a authentic, true source, I think is important for people to be able to have access to that, and not something that's kind of spun by either side, which, I understand why they do that, but I just choose not to. We can't just allow justices to accept cash payments from the people that they have cases in front of them. Marley, that seems like that would just be one of those common sense rules that people follow. But the nuances that I think justices can create, make it a bit more challenging. And I think it's because of this ability to kind of twist and turn things around a little bit. But absolutely, of course they shouldn't. Of course there should not be any kind of compensation from anyone, or even the appearance of impropriety. Absolutely, absolutely. And how can we get that into place and then trust that it's being implemented? And I think that's where that oversight question comes in. You can plead the fifth. Yes, you can plead the fifth. Now, under case law, if you are in criminal court and you plead the fifth, there's case law that says that cannot be held against you by the jury. And that's a jury instruction we give if we've got someone pleading the fifth. That is not true in the Senate. So that particular case would not come in and help. So the implications of pleading the fifth could be, crazy. It would put SCOTUS completely on the defensive. Yes, and I think, too, one of the problems, though, with appearing with their legal counsel is, if their letters are any indication, I'm not sure. Now, ethically, I'm not supposed to say anything that would negatively reflect on my profession, but I will say these two letters from their counsel are ridiculously uninsightful. And so if this was to play with a justice in front of the Supreme Court and having this level of counsel available to them would be detrimental to everybody involved, in my opinion. Does what it wants. Laws are pointless. Well, some people may feel that way, although that's not what my student loans are saying that I'm paying back to go to school to learn about the law. So they would have to impeach him. That would be an entirely new case. Yes, and impeachment is a difficult process. We would have to have a legal reason. There has to be some kind of high crime or some kind of treason situation. I mean, it really takes a lot to go forward on articles of impeachment. Some people may not know that in the House of Representatives. They may not realize that it actually takes real legitimate legal reasons to do articles of impeachment, but it does. It really does. And when you're dealing with a U.S. Supreme Court justice, that's going to have to be the most concise set of articles of impeachment ever written. What can the people do to hold the Supremes accountable? We can't vote them out. True. Bees. True. And I'm glad you asked. I think what we're doing is holding them accountable. I think continuing to ask these questions, continuing to ask for answers and demanding answers is good. Keeping this in the public and keeping this at the forefront of their minds is essential, because in the legal field, no matter what happens, it's that fire that burns the brightest that gets put out first. So I'm not saying set any fires. That would be wrong. No. What I'm saying is the amount of noise that you make on something makes it so that it cannot be ignored. And that is so important. So write your letters, make your phone calls, do your voting, whatever it is, make a video, post some videos, whatever it is, just make it known how you're feeling about the situation with the U.S. Supreme Court. Just make it known. And the more frequently you can do that and the louder you can do that, I think the harder it is for it to be dismissed. And that's true for any legal issue anywhere. And I think it's absolutely essential for the U.S. Supreme Court. You want your Super Bowl ring? Oh, I'm sorry, but that is way over the limit allowed for gifts. Oh, yeah, it's not oh, everyone is corrupt, even the janitor. Oh, now come on. I know some very nice staff people that are working hard in the kitchens and all over DC. But there are definitely a lot of, anytime politics is brought up, it is just a match to kindling right now, and has been. And we're just kind of, I think our country, we fight a lot, and we're really fighting quite a bit right now. So they support the Constitution and go against you socialist ideas. It's okay. Well, socialist ideas, you'd have to be a little bit more specific about that. And I think And that's because I don't quite understand everybody's definition of democracy. So I'm not sure what you mean by socialism. So you'll have to kind of clarify that for me. But I'm not really sure how that would fall. What are you trying to accomplish? What am I personally trying to accomplish? Oh, I'm just chatting with everyone about Supreme Court ethics. So that's my goal, and I can check that off my list. Although I might be getting a little bit loopy. I've been on for a little while now, but yeah, I don't know. I mean, ethics is has no limitations politically, does it? I didn't learn about that in my ethics class and exam that I had to take required before I took the bar exam, and in law school that I had to take in order to graduate. I mean, I don't know the political party that my ethics professors were part of. But I don't think it should, in my opinion, it shouldn't matter. Some things, absolutely, sure, go for it. But ethics is just, it's a different animal. It's not a left or a right. But Brunson is trying to sue Kagan, Jackson, and Sotomayor. Who isn't being sued by Brunson? Honestly, I'm just going to say it. Because if you look at that case, wow. I mean, it looks like complex civil litigation for Microsoft. It's so many people are listed. I looked through there just to make sure my name wasn't listed. So, you can name whoever you want, but it doesn't mean that you've got grounds for standing or that a case can go forward. And, I don't mean any disrespect by that, but that's just kind of how it is. You can put whoever you want. Yeah, I mean, you can put whoever you want in there, but it doesn't mean, I could sue them too, but it doesn't mean that I've got grounds to go forward on a case at all. But I like your TikTok page. You're well, thank you, Stan. I appreciate that. I appreciate that comment. I try to keep things a little bit entertaining in this world of difficult moments. His case does, and it's 234 members have gone. Yeah, I mean, it's a lot. It really is a lot. I can't even imagine trying to make honestly, from a practical point of view, to send a certified copy of the motions to everybody that he's listing. I mean, that's ridiculous. I'm not trying to diminish his right to access the courts, but I am saying when you name that many people in a lawsuit, there's a lot of administrative things that go along with it. So he keeps going at it. I didn't read it. Oh, I did. And that is time I will never get back. But I did read it. And again, everybody has access, but whether or not they're allowed to proceed, that's up to how the law is written. Hold the reps to their oath. Well, good luck with that. They do have ethics that they have to follow, and those, and they have to follow the Constitution. Now, how they have to follow that is the question. And it's actually written in the Constitution that they are immune from liability for the work that they do as representatives. That was specified within the Constitution. So, good luck. I mean, go for it if you want to do that. But the human condition is a framework. Wow, that got deep fast, Kevin. That got real deep fast. Not that I'm against it, but I'm just saying. That's at a level I'm not sure. You didn't read or you wouldn't understand. No, I think I do understand it, but that it may be frustrating to you. And I get that. Hey, girl. Well, hello. Welcome. Good to see you. Thanks for joining. It's Elise, right? Am I saying that right? You'll have to let me know. Second paragraph, 8 word. Is there a typo in there, or am I just seeing it incorrectly? Second paragraph, 8 word. So here, 1, 2, 3. Yes, it was cut off. Maybe he was using a typewriter. No, I did not just say that about the Chief Justice. Shame on me. No, it was cut off. Oh, I'm sure it was a computer. I'm sure it was. So, Yeah, and I don't know what's going. I mean, I get it. I get some people are frustrated, but it's that's just, oh, I'm glad I got your name right. I'm just, I'm Ragnar. I'm sorry. That's just kind of how it is. And well, I guess that's not legit. I'm not really sorry. I'm just supportive of the courts, and the courts are like, it's ridiculous. And I agree. So, you can disagree with that. That's absolutely within your prerogative. Absolutely. Yeah. I mean, it's interesting though, how it's kind of cut off here. It's a little bit Da Vinci Code, but I don't want to say that because that'll start a whole new nobody has. What amendment are you getting that out of that? Well, you have to ZXT Pro. You'll have to maybe rephrase your question as the judge would ask if you were in court. Word processor choice was remarkable. Yes. Well, oh, you just graduated. Oh, good for you, Kevin. Did you just graduate from law school or from undergraduate? What was your undergraduate in? Oh, that's very exciting. Congrats. You need to join a tactical civics, defending the Constitution. And well, I definitely, I'm a big fan of the Constitution. I did swear an oath to it, and I stand by that oath. But I also have decades of knowledge about it too, and I think that helps. Dan Brown v. The Constitution's not working for everyone as of today. We have a long way to go. True, President 46. And, since the beginning of its original signing, it didn't work for everybody. And ever since then, and we've added amendments all the way into the 90s, and there's still amendments on the floor right now that are just missing a few votes in order to get passed. So, the way that the Constitution is written allows for changing and evolving, but it also allows for a historical precedent. So it's a mixed bag for sure. We have a really long way to go, absolutely, but we've also come a long way as well. So there's both levels to that. But yeah, we do have a long way to go. Absolutely. You said they have immunity in the Constitution. Oh, right. Oh, thank you so much. I'm glad you reminded me of that. That's right. I remember opening the book and then closing it up. Let's see. Let's see. Impeachment, elections, Journal of Proceedings, compensation, conflict of civil office, bills, yeas and nays. Let's see. Lay and collect taxes. Migration and importation, privilege of writ of habeas corpus, bill of attainder. Regulation, money shall be drawn, title of nobility, treaty. Oh, hold on. All right, well, hold on just 1 second. Let me pull it up. I know it's surprising, but I haven't memorized every single word in the Constitution. the senators and representatives. Hold on. Nope, that's not it. Hold on. Okay, Section 6, Clause 1. Here we go. Thanks for staying with me. Here we go. All right, are you all with me still? The senators and representatives shall receive a compensation for their services. Now we come down here and it says, no senator or representative shall during the time for which he is elected be appointed to any other civil office. Whoops, I bumped down too fast. Sorry, back up we go. They shall in all cases except treason, felony, and breach of the peace be privileged from arrest during their attendance at the session of their respective houses, and in going to and returning from the same. And for any speech or debate in either house, they shall not be questioned in any other place. So Section 6, Article 1, Section 6, and it's that second part of the first clause. Hopefully everybody still remembers the question. Oh, goodness. Oh, let's see, how far behind did I get? All right, here we go. Yes, there is. It's me. Wow, you've got an eagle eye for that. You're very careful. Are you an editor? Wow, good for you. Yep, there's a couple, and there's a couple more places. I like how the Chief Justice numbered each line. I think that just speaks to how ingrained it is. Did I sign my oath? Well, now that's between me and the person that I took my oath from. When the United States went corporate, they stopped using the Constitution. Well, some people feel that way. Going to mock the Convention of the States. I'm not sure which convention. I reserve the right to mock depending on the kind of convention. Didn't Jefferson think we should write a whole new one every 18 years? Well, Jefferson, I think Jefferson was a little bit bitter because Congress didn't agree to everything in the Declaration of Independence. So I'm not sure exactly his stance on the Constitution, but he was bitter. I think people knew he was a bit bitter. Not to say he wasn't a genius, because he was. But I think there was a little tit for tat going on. A work in progress. Yes, less than 300 years old. And again, with 27 amendments added to it. My understanding, not one person in government has full immunity. Nobody. Well, true. Sovereign or any kind of immunity that's been given, if there's been a violation of a constitutional right, can be overcome. But there are certain types of immunity that cannot. For example, diplomatic immunity. That would be probably the number one best example I could give you. Congress is not government. It's not a corporation. What? Congress is not government. Nope, you lost me. Legal fiction. It cannot have any... Yeah, I'm sorry. I have no idea what you're talking about. Well, if you're going to make the Constitution not work for others, why not just separate the states? Well, we tried that in the Articles of Confederation, and it didn't work. So we had some big problems. Let me have that book. Oh, yes, this is from the Little White House in Key West. The evolution of qualified immunity began in 1871. Yes, 42 U.S.C. U.S. Code, that's exactly right. And it's been added to quite a bit. I'm actually putting together a post on which cases the U.S. Supreme Court has decided regarding qualified immunity and how it's evolved over the years. So keep an eye out for that. I've got cases you can pull in and cite. We'll say that whether a president can pardon himself isn't a major question. Well, yeah. Now, I believe too, and I won't spend too much time, but I believe actually within the Constitution, it says something about how under Article 2, that pardons cannot be given for impeachment. Now, if it's something other than impeachment, I'm not sure. I'd have to look that up. I'm way behind here in the questions, so let me try to hurry up here. I'm sorry. Okay. Nowhere in that does it grant immunity. Okay, if you say so. I've heard the Santa Claus isn't real. Well, listen, dude, about the Santa Claus, I think that's private, confidential. Santa Claus, client immunity. It's not a state bit, still part of the United States. Right. Try flying over DC. Yeah, it's a fact. It's documented, just like being a bar member when you're required to. I'm not actually an American Bar Association member. I do not have a membership to that. I am licensed under my state Supreme Court, Macon of States, Williamsburg, okay. Can't have immunity until you swear an oath and uphold it. Well, you'd have to cite me some case law for me to agree with that. District of Columbia. Yes, it does come directly from the Constitution. And that's also an interesting part of the Hamilton musical. It's a corporate, it's a legal fiction. Okay. Oh, there's nothing more educational and comforting than constitutional law and TikTok. Well, right. Am I right? What's better than that? Convention of the States. Our states right now, we're kind of fighting a lot, so I'm not sure that would be a good idea. I'm not sure. This would kind of be a bad time. I can freeze the comments, I know, but it's so fun for everybody else to kind of talk about various things. Lots of people have some great comments in here. I just love it. I love it so much. Are you aware of any challenges to Article 1, Section 3, Clause 3? Well, let's see. Article 1, Section 3, Clause 3. Not off the top of my head. Ford pardoned Nixon. Yes, but that pardon was unique because there hadn't been any official charges at that point, if I remember. Pardons are admission of guilt, just FYI. True, but according to the rules of evidence, if you have a pardon, whatever you've been pardoned for is a prior bad act that cannot be admitted in court. I know, right? Did I blow your minds? So although you have been pardoned, actually getting that evidence into court can be another issue. Law of War from the Department of Defense, right? Article 1, Section 2, Clause 3. Move the book. Did I move it? Is it out of the way? I'm a little bit behind on the comments here. Right. He did resign voluntarily, but there was absolutely discussion about some criminal charges against him. And I don't believe any charges were brought because I believe Ford pardoned any potential wrongdoing out of that situation, which made it very unique. Article 2, Section 2, Clause 1. Oh, in the Garland case, yes. Oh, thank you very much, Will. Appreciate that. Article 2, Section 1, Clause 1. Section 1, Section 2, sorry. It's getting late. I've been on for almost 3 hours now. Oh my goodness. Oh, Clause 1. Right. Power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. Oh, very good. Thank you. Thank you very much. Excellent. That's right. That is right. No double jeopardy. Yep. And yeah, it's interesting how pardons can play out and having that evidence presented in court and why you would need it too. So, I think too, our rules regarding evidence is a different issue as opposed to it being made known to the public. And I think that's quite a bit different. So he did resign to avoid impeachment. He did. And, there's some great cases that came out of that situation. And a lot of our ethics rules came out of that situation. This entire Ethics Act that we've been talking about, Ethics in Government of 1978, the timing on that is pretty interesting compared to with what was going on with Nixon. So there was a lot of laws and rules that came into place after that. So Oh, yes, of course. Of course. Is it Marilee? Yes, I'm thankful for all of you. Well, I'm just saying it's kind of important why we have that. But oh, good, I'm glad. But yeah, I'm so pleased that people are interested and would like to know. I'm happy to give as many resources available to anyone as possible. And it's so much more fun, honestly, when I can lecture like this because then people could just kind of come and go. No, it didn't sound sarcastic. No, not at all. I'm just, yep. Nope, I got you. I appreciate it. I appreciate your noticing that. I try to kind of tie everything together into the intricate web of the law and the Constitution. We weave it all together. But yes, it's nice that people can kind of come and go. And if it gets boring, you can go and then come back if you've got other questions and so on. So that is very enjoyable for me too. So, but I do have to probably sign off here pretty soon. My battery, it's not necessarily my battery's about to go out, but my phone is on fire. So, oh my God. And I've still got work tomorrow, one more day of the work week. But thank you everybody that came tonight. Oh my gosh, this has been so much fun. I've really enjoyed all of the questions and interest in this topic, and great questions on all sides. I think it's just really, really good to ask as many questions as possible and bring up those issues with as many people. So hopefully this kind of gives you a direction to go in if you want to look up these rules for yourself. I had such a hard time getting this out of the holding pattern for the TikTok. So I'm not sure I'll be able to get a video posted on this, but I'll try. I'll try to see what I can do. I will take this live and have it up on my YouTube channel for anyone who's interested. If you wanted to review and see what documents I'm talking about, I will put it up on YouTube, and it's Attorney DI and on YouTube. So you can go look it up and fast forward and kind of get to what you're interested in. I'll try to have that up probably within the next, it'll take me a few hours, but I will do my best to get that up. Also, my previous lives, I am slowly starting to get posted as well. I'm not posting original content to YouTube at this point. I did try in the beginning, but wow, the comments, goodness, I just could not get control of the comments there. So maybe I will again in the future. But at this point, I'm just kind of putting these really long lectures up for anyone that would like to reference any of the documents or rules that I've been talking about. But thank you again, everybody, for coming. This was so much fun. I will probably be doing another case next week. So I'm trying to kind of alternate between case as well as the law, so statute and so on. I'll be kind of flip-flopping back and forth. I do plan to do the ICWA case on Tuesday of next week. So if you're interested in that, I will be posting a notice when the time comes for that. So thank you again for joining me. Yes, it is. It's quite warm. I'm going to get the marshmallows out here and make some s'mores. Those have not been gifted to me. I bought those with my own money, so I don't have to. Those are not an expense for education. But thank you all again for coming. And I hope you will join me next week or next time. And oh my gosh, Texas. Oh, you're melting. Good luck to you. Goodness. I wish you lots of luck down in Texas. But yeah, to reimburse. Nope, not asking for reimbursement. Nope, that's fine. But yeah, it really is, isn't it? It is. But take care, everybody. Make sure if you've got any reimbursed. Nope, I'm fine. Nope. Not seeking any kind of monetary gain at all here. But yes, so please leave any questions in any of the videos I've posted, and I will catch you all next week. Take care. Have a great night, everybody.